and humanitarian considerations, it has been decided to proceed as follows. Foreigners issue. The purpose of detection and deletion of foreigners 1/1/1966 shall be the base date and year. All persons who came to Assam prior to 1/1/66, including those amongst them whose name appeared in the electoral rolls used in 1967 elections, shall be regularized. Foreigners who came to Assam after 1/1/1966, inclusive, and up to 24th March 1971, shall be detected in accordance with the provisions of the Foreigners Act 1946 and the Foreigners Tribunals Order 1939. Names of foreigners so detected will be deleted from the electoral rolls in force. Such persons will be required to register themselves before the registration officers of the respective districts in accordance with the provisions of the Registration and Foreigners Act 1939 and the Registration of Foreigners Rules 1939. For this purpose, the Government of India will undertake suitable strengthening of government machinery. On the expiry of the period of 10 years following the date of detection, the names of all such persons which have been deleted from the electoral rolls shall be restored. All persons who were expelled earlier but have since re-entered illegally into Assam shall be expelled. Foreigners who came to Assam on or after 25th March 1971 shall continue to be detected, deleted and expelled in accordance with law. Immediate and practical steps shall be taken to expel such foreigners. Emphasis supplied. The government will give due consideration to certain difficulties expressed by AASU, AAGSP regarding the implementation of Illegal Migrants Determination of Tribunals Act 1983. Safeguards and Economic Development. Clause 6. Constitutional, legislative and administrative safeguards as may be appropriate shall be provided to protect, preserve and promote the cultural, social, linguistic identity and heritage of the Assamese people. The government takes this opportunity to renew their commitment for the speedy all-round economic development of Assam so as to improve the standard of living of the people. Special emphasis will be placed on the education and the science and technology through establishment of national institutions. Other issues. The government will arrange for the issue of citizenship certificate in future only by authorities of the central government. Specific complaints that may be made by AASU, AAGSP about irregular issuance of Indian citizenship certificates, ICC, will be looked into. 9.1. The international border shall be made secure against future infiltration by erection of physical barriers like walls, barbed wire fencing, and other obstacles at appropriate places. Patrolling by security forces on land and riverine routes all along the international border shall be adequately intensified in order to further strengthen the security arrangements to prevent effectively future infiltration. An adequate number of checkposts shall be set up. Besides the arrangement mentioned above and keeping in view security considerations, a road all along the international border shall be constructed so as to facilitate patrolling by the security forces. Land between border and roads should be kept free of human habitation wherever possible. Riverine patrolling along with international border would be intensified. All effective measures would be adopted to prevent infiltrators crossing or attempting to cross the international border. It will be ensured that relevant laws for the prevention of encroachment of government lands and lands of tribal belts and blocks are strictly enforced and unauthorized encroachers evicted as laid down under such laws. It will be ensured that the law restricting acquisition of immovable property by foreigners in Assam is strictly enforced. It will be ensured that birth and death registers are duly maintained. Restoration of normalcy. The AASU and the AAGSP call off the agitation, assure full cooperation, and dedicate themselves to the development of the country. The central and state governments have agreed to review with sympathy and withdraw cases of disciplinary action taken against employees in the context of the agitation and to ensure that there is no victimization. Frame a scheme for ex gratia payment to next of kin of those who were killed in the course of agitation. Give sympathetic consideration to proposals for relaxation of upper age limit for employment in public service in Assam, having regard to exceptional situations that prevail in the holding of academic and competitive examinations, etc., in the context of the agitation in Assam. Undertake review of detention cases, if any, as well as cases against persons charged with criminal offences in connection with the agitation, except those charged with the commission of heinous offences. Consider withdrawal of prohibitory orders and notifications in force, if any. The Ministry of Home Affairs will be the nodal ministry for the implementation of the above. And thereafter, your lordships will see that there are the signatures of the various persons, including and in the presence of the Prime Minister of India, 15th August 1985 at New Delhi. It was in pursuance of this accord that Section 6A was inserted in the Citizenship Act in 1985. The statement of objects and reasons of the Act specifically states that the legislation required to give effect to the Assam Accord. Section 6A states as follows. With your permission, I'll just read through Section 6A as well. Special provisions as to citizenship of persons covered by the Assam Accord. For the purposes of this section, Assam means the territories included in the state of Assam immediately before the commencement of the Citizenship Amendment Act 1985. Detected to be a foreigner means detected to be a foreigner in accordance with the provisions of the Foreigners Act and the Foreigners Tribunal's Order 1964 by a tribunal constituted under the said order. Specified territory means the territories included in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. D. A person shall be deemed to be of Indian origin if he or either of his parents or any of his grandparents was born in undivided India. E. A person shall be deemed to be detected to be a foreigner on the date of which the tribunal constituted under the Foreigners Tribunal Order 64 submits its opinion to the effect that he is a foreigner to the officer or the authority concerned. Subsection 2, subject to the provisions of subsections 6 and 7, all persons of Indian origin who came before 1st day of January 1966 to Assam from the specified territory, including such of those whose names were included in the electoral rolls used for the purposes of the general election to the House of the People held in 1967, and who have been ordinarily resident in Assam since their dates of their entry into Assam, shall be deemed to be citizens of India from the 1st day of January 1966. Subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam on or after the 1st day of January 1966, but before 25th day of March 1971 from the specified territory, and B, has since the date of his entry into Assam been ordinarily resident in Assam, and C, has been detected to be a foreigner, shall register himself in accordance with the rules made by the central government in this behalf under Section 18, and such authority thereafter in this subsection referred to as the registering authority, as may be specified in such rules, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. Then the explanation. In the case of every person seeking registration under the subsection, the opinion of the tribunal constituted under the Foreigners Tribunal's Order 1964, holding such person to be a foreigner, shall be deemed to be sufficient proof of the requirement under Clause C of this subsection. And if any question arises as to whether such person complies with any of the other requirements under this subsection, the registering authority shall, 1. If such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. And 2, if such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order having jurisdiction in accordance with such rules as the central government may make in this behalf under Section 18 and decide the question in conformity with the opinion received on such reference. Subsection 4. A person registering under subsection 3 shall have, as from the date on which he has been detected to be a foreigner, and till the expiry of a period of 10 years from that date, the same rights and obligations as a citizen of India, including the right to obtain a passport under the Passports Act and the obligations connected therewith, but shall not be entitled to have his name included in any electoral roll for any assembly or parliamentary constituency at any time before the expiry of the said period of 10 years. A person registered under subsection 3 shall be deemed to be a citizen of India for all purposes as from the date of expiry of the period of 10 years from the date on which he has been detected to be a foreigner, without prejudice to the provisions of section 8. A. If any person referred to in subsection 2 submits in the prescribed manner and form to the prescribed authority within 60 days from the commencement of the Citizenship Amendment Act 1985, a declaration that he does not wish to be a citizen of India, such person shall not be deemed to have become a citizen of India under that subsection. B. If any person referred to in subsection 3 submits in the prescribed manner and form and to the prescribed authority within 60 days from the date of the commencement of the 1985 amendment, or from the date on which he has been detected to be a foreigner, whichever is later, a declaration that he does not wish to be governed by the provisions of that subsection and subsection 4 and 5, it shall not be necessary for such person to register himself under subsection 3. Where a person required to file a declaration under this subsection does not have the capacity to enter into a contract, such declaration may be filed on his behalf by any person competent under the law for the time being enforced to act on his behalf. Nothing under subsections 2 to 6 shall apply in relation to any person, A, who immediately before the commencement of the Citizenship Act 1985 is a citizen of India, B, who was expelled from India before the commencement of the Citizenship Amendment Act 1985 under the Foreigners Act 1946 for a year. 8. Save as otherwise provided in this section, the provisions of this section shall have effect notwithstanding anything contained in any other law for the time being in force. It will be seen that as part of the Assam Accord, a huge number of illegal migrants were made deemed citizens of India. It is interesting to note that Parliament has not enacted any law pertaining to refugees from other countries. Refugee status can be granted and has been granted in India through executive orders passed by the central government. In any case, Section 6A did not merely rest content upon granting refugee status to those who were illegal migrants from East Pakistan, but went on to grant them the benefit of citizenship of India, so that all persons who have migrated before 1966 and all persons who migrated before 25th March 1971 respectively were to become citizens of India either immediately or, as is mentioned by the Act, after a period of 10 years, once there has been a determination that they have in fact settled in India between 66 and 71. On 8th November 1998, Lieutenant Governor S.K. Sinha, the then Governor of Assam, submitted an extensive report to the then President of India on the grave threat posed by the influx of people from Bangladesh to Assam. He said, the dangerous consequence of large-scale illegal migration from Bangladesh, both for the people of Assam and more for the nation as a whole, need to be emphatically stressed. No misconceived and mistaken notions of secularism should be allowed to come in the way of doing so. As a result of population movement from Bangladesh, the spectre looms large of the indigenous people of Assam being reduced to a minority in their home state. Their cultural survival will be in jeopardy, their political control will be weakened, and their employment opportunities will be undermined. The silent and invidious demographic invasion of Assam may result in a loss of geostrategically vital districts of Lower Assam. The influx of illegal migrants is turning these districts into a Muslim majority region. It will then only be a matter of time when a demand for their merger with Bangladesh may be made. The rapid growth of international Islamic fundamentalism may provide the driving force for this demand. In this context, it is pertinent that Bangladesh has long discarded secularism and has chosen to become an Islamic state. Loss of Lower Assam will sever the entire landmass of the northeast from the rest of India, and the rich natural resources of that region will be lost to the nation. It was in this backdrop that a writ petition, being writ petition number 131 of 2000, was filed by Sarbananda Sonowal, assailing the constitutional validity of the Illegal Migrants Determination of Tribunals Act 1983 and the rules made thereunder. In a judgment reported in 2005, 5 SCC 665, this court referred to the Assam Accord and to the huge influx of illegal migrants into the state of Assam and came to the conclusion that the 1983 Act and the rules made thereunder operated in the reverse direction. That is, instead of seeing that illegal migrants are deported, it did the opposite by placing the burden of proof on the state to prove that a person happens to be an illegal migrant. The court went on to hold that Article 355 of the Constitution had been violated, inasmuch as the Union had failed to protect the state of Assam against an external aggression and internal disturbance caused by the huge influx of illegal migrants from Bangladesh to Assam, and went on to hold the 1983 Act to be violative of Article 14 as well. Inasmuch as the Act was struck down and the Immigrants Expulsion from Assam Act 1950, together with the Foreigners Act and Foreigners Tribunal Order of 1964, were now to be the tools in the hands of the government to do the job of detecting illegal migrants who were then to be deported. On 14th July 2004, in response to an unstarred question pertaining to the deportation of the illegal Bangladeshi migrants, the Minister of State, Home Affairs, submitted a statement to Parliament indicating therein that the estimated number of illegal Bangladeshi migrants into India as on 31st December 2001 was 1.20 crores, out of which 50 lakhs were in Assam. Given the magnitude of the problem, a Foreigners Tribunals for Assam Order of 2006 was promulgated, which was again struck down, being found to be unreasonable and arbitrary, and which, instead of expeditiously discovering the illegal migrants and deporting them, again did the opposite. It was in Sarbananda Sonowal 2 versus Union of India, in the second Sonowal writ petition, that the Supreme Court struck down this order. In the year 2012 and 2014, large-scale riots took place in Assam, resulting in the deaths of a large number of persons. It is in this background that the present writ petitions have been filed. So now this was, my lords, the narrative in terms of the sequence building up and some of the statutory provisions. Now we go to the second part of the judgment. A preliminary submission was urged by the learned Additional Solicitor General, Mr. Neeraj Kaul, that Section 6A, having been enacted in 1985, a challenge made in 2012 would be barred by delay and laches. We will first advert to the preliminary submissions in order to see whether we will proceed further to determine the issues raised in these writ petitions. Then writ petitions, when the prayers are set out, with your permission, I'll skip this part. Then please go to para 21. Article 32 of the Constitution has been described as the heart and soul of the constitutional guarantees and the rights to move the Supreme Court for enforcement of all or any of the fundamental rights conferred by Part 3 of the Constitution. This article is therefore itself a fundamental right, and it is in this backdrop that we need to address the preliminary submissions. Tilokchand Motichand, a constitution bench, was asked to decide the constitutional validity of Section 12A(4) of the Bombay Sales Tax Act. The precise ground for challenge was a violation of Article 19(1)(f) of the Constitution. A majority of 3 out of 5 judges held that the petition was hit by the doctrine of leches and hence dismissed the petition. In so holding, each of the judges arrived at a differing reason as to why the petitions under Article 32 ought to be dismissed on the ground of delay and leches. In paragraphs 9, 10, and 11, Chief Justice Hidayatullah held, in India, we have a Limitation Act which prescribes different periods of limitations for suits, petitions, and applications. There are also residuary articles which prescribe limitation in those cases where no express period is provided. If it were a matter of a suit or application, either an appropriate article or the residuary article would have been applied. But a petition under Article 32 is not a suit, and it is also not a petition or an application to which the Limitation Act applies. To put curbs on the way of enforcement of fundamental rights through legislative actions might well be questioned under Article 13(3). The reason is also quite clear. If a short period of limitation were prescribed, the fundamental right might well be frustrated. Prescribing too long a period might enable stale claims to be made to the detriment of other rights which might emerge. If then there is no period prescribed, what is the standard for the court to follow? I should say that the utmost expedition is a sine qua non for such claims. The party aggrieved must move the court at the earliest possible time and explain satisfactorily all semblance of delay. I am not indicating any period which may be regarded as the ultimate limit for the action, for that would be taking upon myself legislative functions. In England, a period of 6 months has been provided statutorily, but that could be because there is no guaranteed remedy and the matter is one entirely of discretion. In India, I will only say that each case will have to be considered on its own facts. Where there is an appearance of avoidable delay, and this delay affects the merits of the claim, the court will consider it and in an appropriate case hold the party disentitled to invoke the extraordinary jurisdiction. Therefore, the question is one of discretion for the court to follow from case to case. There's no lower limit and there is no upper limit. A case may be brought within the Limitation Act by reason of some article, but this court need not necessarily give the total time to the litigant to move this court under Article 32. Similarly, in a suitable case, this court may entertain such a petition even after a lapse of time. It will all depend on the breach of the fundamental right and the remedy claimed are when and how the delay arose. Justice Sikri held as follows. So, if your lordship permits, I'll skip this because Justice Bachawat, etc., they all hold that this discretion is retained. And then you may just go to page internal page 19, print page 1390. The sole dissentient was Justice Hegde, who decided that Article 32 itself being a fundamental right, there's no question of delay being used to non-suit a petitioner at the threshold. His minority view is as follows. Thereafter, there's a quotation from Justice Hegde. May I take you to paragraph 23, please, which is at page 1391. It will thus be seen that Hidayatullah, Chief Justice, did not lay down any fixed period. According to him, there's no lower limit or upper limit, except that utmost expedition is a sine qua non for moving the petition under Article 32. The learned Chief Justice left it to be decided on the facts of each case, depending on what the breach of the fundamental right is, what remedy claimed is, and when and how the delay arose. Justice Sikri, on the other hand, was in favor of an inflexible time limit that is not beyond 1 year. Both Justice Bachawat and Mittal would ask the question as to whether time had run out, and if so, whether the writ petition ought to be dismissed. As a result, it is clear from a reading of these differing judgments that the ratio of the Constitution bench can be broadly stated to be that a writ petition filed under Article 32 can be dismissed on the ground of delay. Beyond that, there is no discernible ratio as to the majority, as no majority can be cobbled up for deciding on what basis such writ petition can be so dismissed. Close to the heels of the judgment in Rabindranath Bose versus Union of India, a fervent plea was made to reconsider the judgment in Tilokchand. This plea was turned down, and it was held that a stale claim of 15 years to challenge appointments and promotions already made without any explanation for so moving after 15 years would result in dismissal of an Article 32 petition, more so when rights had accrued to the respondents in the case. The court held, and thereafter, my lords, there is an excerpt. May I take your lordships to para 26 at the foot of page 1393. In Ramchandra Devdar versus State of Maharashtra, a constitution bench was invited to dismiss a petition under Article 32 on the ground of delay of laches. The petitioner, having approached the court after a delay of at least 8 years, the court held that barring a writ petition containing stale claims is not a rule of law, but a rule of practice based on sound and proper discretion. There is no inviolable rule that whenever there is delay, the court must necessarily refuse to entertain the petition. After referring to Tilokchand and Rabindranath Bose, the court held that the claim for enforcement of a fundamental right of equal opportunity under Article 16 cannot be dismissed solely on the ground of delay and laches, etc. The court also went on to hold that promotion being provisional, no rights have been conferred on those who are promoted, whose interests can therefore be defeated if ultimately it is found that such promotions are not warranted. In express publications, the employer newspaper wished to challenge paragraph 80 of the scheme of 1952, which came into force in 56. The challenge was made in a writ petition under Article 32, 45 years later in 2001. This was turned down by a bench of 2 judges with the caveat that if the case of the petitioners that the passage of time a certain provision had become unconstitutional, then obviously the very passage of time would not amount to delay, for such a petition would not be entertained. Similarly, in Tridip, a bench of 2 judges held that there's no upper and no lower limit when it comes to an Article 32 petition. It all depends on the breach of a particular fundamental right, the remedy claimed, and how the delay arose. On facts, the petition was turned down as there was an unexplained delay of 10 years. In Bangalore City, a 2-judge bench understood the ratio of Tilokchand as follows. And there is an excerpt. Please go to paragraph 30. It will be seen that in the present case, the petitioners in the various writ petitions represent the entire people, the tribal and non-tribal population of the state of Assam. In their petition, they have raised a plea that the sovereignty and integrity of India is itself at stake as a massive influx of illegal migrants from a neighboring country has affected this core constitutional value. That in fact it has been held in Sonowal's case that such an influx is external aggression within the meaning of Article 355 of the Constitution of India, and that the central government has done precious little to stem the tide, thereby resulting in a violation of Article 355. As a result of this huge influx, periodic clashes have taken place between the citizens of India and these migrants, resulting into loss of life and property, sounding in violation of Articles 21 and 29 of the Constitution of the Assamese people as a whole. Not only is there an assault on life of the citizenry of the state of Assam, but there is an assault on their way of life as well. The culture of an entire people is being eroded in such a way that they will ultimately be swamped by persons who have no right to continue to live in this country. The petitioners have also argued that this honorable court in Sonowal has specifically held in para 79 thereof that Bangladeshi nationals who have illegally crossed the border and have trespassed into Assam, who are living in other parts of the country, have no legal right of any kind to remain in India, and they are liable to be deported. They have also raised a fervent plea that Article 14 also continues to be violated as sections 6A 3 to 5 are not time-bound but are ongoing. Given the contentions raised specifically with regard to the pleas under Articles 21 and 29 as a whole class of people, namely the tribal and non-tribal tribal citizens of Assam, and given the fact that agitations on this score are ongoing, we do not feel that petitions of this kind can be dismissed at the threshold on the ground of delay and laches. Indeed, if we were to do so, we would be guilty of shirking our constitutional duty to protect the lives of our own citizens and their culture. In fact, the time has come to have a relook at the doctrine of laches altogether when it comes to violations of Article 21 and 29. Tilokchand is a judgment involving property rights of individuals. Ramchandra, also a constitution bench of 5 judges, has held that the fundamental right under Article 16 cannot be wished away solely on genuine grounds of delay. Since Tilokchand was decided, there have been important strides made in the law. Property rights have been removed from Part 3 of the Constitution altogether by the Constitution 44th Amendment Act. The same amendment made it clear that even during an emergency, the fundamental right under Article 21 can never be suspended, and amended Article 359(1) to give effect to this. In Maneka Gandhi versus Union of India, decided 9 years after Tilokchand, Article 21 has been given its new dimension, and pursuant to the new dimension, a huge number of rights have come under the umbrella of Article 21. For an enumeration of these rights, see Kapila Hingorani versus State of Bihar. Further, in Olga Tellis, it has been conclusively held that all fundamental rights cannot be waived. Given these important developments in the law, the time has come for this court to say that at least when it comes to violations of fundamental rights to life and personal liberty, delay or laches by itself without more would not be sufficient to shut the doors of the court on the petitioner. Coming now to the merits, now the third part. Coming now to the merits, we have heard several counsel for the petitioners who have raised a number of points which have been rebutted by the Council for the Union of India and the state. We feel that the following questions need to be answered by an appropriate bench, as most of them are substantial questions as to the interpretation of the Constitution and have been decided by a minimum of 5 judges under Article 145(3). An enumeration of these questions is as follows. Whether Articles 10 and 11 of the Constitution permit the enactment of Section 6A of the Citizenship Act, inasmuch as Section 6A, in prescribing a cut-off date different from the cut-off date prescribed in Article 6, can do so without a variation of Article 6 itself, regard in particular being had to the phraseology of Article 4(2) read with Article 368(1). 2. Whether Section 6A violates Articles 325 and 326 of the Constitution of India, in that it has diluted the political rights of the citizens of the state of Assam. 3. What is the scope of the fundamental right contained in Article 29(1)? Is the fundamental right absolute in its terms? In particular, what is the meaning of the expression culture and the expression conserve? Whether Section 6 capital A violates Article 29(1). 4. Whether Section 6A violates Article 355. What is the true interpretation of Article 355? Would an influx of illegal migrants into a state of India constitute external aggression and or internal disturbance? Does the expression state occurring in this article refer only to the territorial region, or does it also include the people living in the state, which would include their culture and identity? Whether Section 6A violates Article 14 in that it singles out Assam from other border states which comprise a distinct class and discriminates against it. Also, whether there is no rational basis for having a separate cut-off date for regularizing illegal immigrants who enter Assam as opposed to the rest of the country. And 6. Whether Section 6A violates Article 21 in that the lives and personal liberty of the citizens of Assam has been affected adversely by the massive influx of illegal migrants from Bangladesh. 7, whether delay is a factor that can be taken into account in molding relief under a petition filed under Article 32 of the Constitution. Whether after a large number of migrants from East Pakistan have enjoyed rights as citizens of India for over 40 years, any relief can be given in the petitions filed in the present cases. 9, whether Section 6A violates the basic premise of the Constitution and Citizenship Act in that it permits a citizen who have allegedly not lost their citizenship of East Pakistan to become deemed citizens of India, thereby conferring dual citizenship on such persons. Whether Section 6A violates the fundamental basis of Section 5(1) proviso and Section 5(2) of the Citizenship Act as it stood in 1985, in that it permits a class of migrants to become deemed citizens of India without any reciprocity from Bangladesh and without taking the oath of allegiance to the Indian Constitution. 11, whether immigrants' expulsion from Assam Act 1950, being a special enactment qua immigrants into Assam, alone can apply to migrants from East Pakistan and Bangladesh to the exclusion of the General Foreigners Act and Foreigners Tribunal's Order 1964 made thereunder. Whether Section 6A violates the rule of law in that it gives way to political expediency and not to the government according to law. 13, whether Section 6A violates the fundamental right in that no mechanism is provided to determine which persons are ordinarily resident in Assam since the dates of their entry into Assam, thus granting deemed citizenship to such persons arbitrarily. These matters be placed before the Chief Justice for constitution of an appropriate bench to answer the above questions. As notice is yet to be issued in 876, we direct that notice be given, be issued and served, etc., on the petitioners. Then there is a statement of objects and reasons for the enactment of Section 6A states. This is not on your Lordship's record, but we have a separate document which we will show your Lordship. But essentially, the SOR for the bill, which eventually became the 1985 Act, indicates the purposes, etc., with regard to the Act. Now, my Lords, may I just... there are certain extracts here. We read them or no? Then, my Lords, the court examines further directions, because it says that at this point of time, we must assume that the statute itself is valid and constitutional, and therefore it proceeds to issue various directions with regard to fencing, etc., and obligations which are there under the Act. So that's the structure of this judgment, the reference order. Which part? What is it? Your Lordships are pleased to just go back to to page 1398.
1398.
After para 35, in para 35, as your Lordship sees, as Section 6A of the Citizenship Act must be deemed to be valid until a larger bench decides these matters, we will proceed for the purposes of the order on the footing that Section 6A is valid. So it makes the reference, etc. Your Lordships have seen, have now a very good sense of what our submissions are going to be as well. In terms of there are elements of fundamental rights, there are elements of constitutional competence, elements as to whether this can really be contrary to the citizenship provisions in the Constitution, including provisions with regard to right to vote, etc. Yeah. Well, so on the magnitude of the problems, I'm going to address your Lordships, but since it is here, since some part of what we are going to submit is in paragraph 36 onwards, may I just read a few more paragraphs here and then I'll go to my petition and our grounds. So please see para 36, which is at page 1398. As the statement of objects and reasons for the enactment of Section 6A states, the said section was inserted into the statute book in 1985 to implement one part of the Assam Accord dated 15th August 1985. The Assam Accord contained various provisions providing for reciprocal obligations. These are largely contained in paragraphs 5, 6, 9, and 10, which read as under. The purpose of detection and deletion of foreigners, 1166 shall be the base date and year. All persons who come into Assam prior to 1166, including those amongst them whose names appear on the electoral rolls used in the 66 elections, shall be regularized. Foreigners who came to Assam after 1166 inclusive and up to 24,371 shall be deleted in accordance with the provisions of the Foreigners Act and the Foreigners Tribunals Order 1939. Names of foreigners so detected will be deleted from the electoral rolls in force. Such person will be required to register themselves before the registration officers of the respective districts in accordance with the provisions of the Registration of Foreigners Act and the Registration of Foreigners Rules 1939. For this purpose, the Government of India will undertake suitable strengthening of the government machinery. On the expiry of the period of 10 years following the date of detection, the names of all such persons which have been deleted from the electoral roll shall be restored. All persons who were expelled earlier but have since re-entered illegally into Assam shall be expelled. Foreigners who came into Assam on or after 25th March 71 shall continue to be detected, deleted, and expelled in accordance with law. Immediate and practical steps shall be taken to expel such foreigners. The government will then please see serial number 6. Constitutional, legislative, and administrative safeguards, as may be appropriate, shall be provided to protect, preserve, and promote the cultural, social, linguistic identity and heritage of the Assamese people. And 9.1, the international border shall be made secure against future infiltration by erection of physical barriers like walls, barbed wire, fencing, and other obstacles at appropriate places. Patrolling by security forces on land and riverine routes all along the international border shall be adequately intensified in order to further strengthen and secure the arrangements to prevent effectively future infiltration. An adequate number of checkposts shall be drawn. Para 37. The Sonoval Millards first, dealing with so-and-so, please see the quotations from this judgment, and then I'll be reading certain other paragraphs, but your lordships may just see the quoted portion, which starts at the foot of page 1399. As a result of students' movement and the ensuing negotiations, a memorandum of settlement dated 15th August 85 was entered into between the All Assam Students Union and the Union of India and the state of Assam, which is commonly known as the Assam Accord. The terms of the accord specifically provided that steps would be taken to detect and deport illegal migrants from Assam, and it also contained a clause that the government will give due consideration to certain difficulties expressed by AASU, AAGSP regarding the implementation of the Illegal Migrants Determination of Tribunals Act 83. The accord further provided that foreigners who have entered into India after 25th March 71 will continue to be detected, their names deleted from the electoral rolls, and they will be deported from India. In pursuance of this provision, the Citizenship Act 1955 was amended by Act 65 of 1985, and Section 6A was inserted with the heading Special Provisions as to Citizenship covered by the Assam Accord. It provides that the term detected to be a foreigner shall mean so detected under the Foreigners Act and the Foreigners Tribunals Order 64 framed thereunder. Under the said provisions, a person of Indian origin as defined under Section 6A3 who entered into Assam prior to 1166 and has been a resident of Assam since then is deemed to be a citizen of India. However, if such a person entered into Assam between 1st January 66 and 25th March 71 and has been detected to be a foreigner under the Foreigners Act, then he is not entitled to be included in the electoral list for a period of 10 years from the date of detection. This amendment of the Citizenship Act makes it clear that the question of determination of detection of a foreigner is to be governed by the provisions of the existing central legislation, that's the Foreigners Act 46 and the Foreigners Tribunals Order 1964. The Union of India has filed a counter affidavit which has been sworn by so-and-so. In para 7 of the affidavit, it has been stated that a proposal to repeal the IMDT Act is under consideration. Yes. Then your lordships will go to, there is a status report which is quoted on page 1401 from that counter affidavit. Continuing influx of Bangladeshi nationals into India has been on account of a variety of reasons, including religious and economic. There is a combination of factors on both sides which are responsible for a continuing influx of illegal immigration from Bangladesh. The important push factors on the Bangladesh side include steep and continuous increase in population, sharp deterioration in the land-man ratio, low rates of economic growth, particularly poor performance in agriculture. The pull factors on the Indian side include ethnic proximity and kinship, enabling easy shelter to the immigrants, porous and easily negotiable border with Bangladesh, better economic opportunities, interested religious and political elements encouraging immigration. It's difficult to make a realistic estimate of the number of illegal immigrants from Bangladesh because they enter surreptitiously and are able to mingle easily with the local population due to ethnic and linguistic similarities. The demographic composition of the districts bordering Bangladesh has altered with the illegal immigration from Bangladesh. The districts of Assam and West Bengal bordering Bangladesh have recorded growth of population higher than the national average. The states of Meghalaya, Mizoram and Tripura have also recorded high rates of population growth. Illegal immigrants from Bangladesh have also been using West Bengal as a corridor to migrate to other parts of the country. The large-scale influx of illegal Bangladesh immigrants has led to large tracts of sensitive international borders being occupied by foreigners. This has serious implications for internal security. The types of illegal immigrants are as follows. A. Those who come with valid visa documents and overstay. B. Those who come with forged visa documents. And C. Those who entered surreptitiously. During the talks between the Prime Minister of India and Bangladesh, Prime Ministers of India and Bangladesh in February 72, the Prime Minister of Bangladesh had assured the return of all Bangladesh nationals who had taken shelter in India since 25th March 1971. Accordingly, a circular was issued by the Government of India on 10th September 1972, setting out guidelines for action to be taken in respect of persons who have come to India from Bangladesh. According to this circular, those Bangladesh nationals who had come to India before 25th March 71 were not to be sent back, and those who entered India in and after that date were to be repatriated. In para 12 of the counter affidavit, it has been stated that the basic objection of the petitioner is under consideration of the central government that the IMDT Act and the rules made thereunder are not effective in comparison to the Foreigners Act, which is applicable to the whole country except to the state of Assam. In paragraph 18 of the counter affidavit, it is stated that the administrative powers in respect of IMDT Act have been delegated to the government of Assam under section 21 of the aforesaid Act. The second subparagraph of para 18 and 19 of the counter affidavit are important and are being reproduced below. Then this is, my lords, further on the IMDT Act, which eventually came to be struck down. Now please go to page 1405. Para 38. The state of Assam has prepared a white paper on foreigners issue dated 20th October 2012. We propose to extract large portions of this paper only to show that even as on 20th October 2012, very little has been done to implement paragraphs 5, part 6, 9 and 10 of the Assam Accord. So these were the portions which were extracted, etc. And then your lordships will see that there is an lengthy extract with regard to the various other promises and obligations which were mentioned and extracted under the Assam Accord have as such not been complied with. If your Lordship is pleased to just turn to page 1412, para 39. It will be seen that a number of tribunals set up is abysmally low, resulting in an abysmally low number of decisions of these tribunals. What is interesting to know is that whereas almost 1,50,000 persons were deported between 61 to 65 under the Immigrants Expulsion of Assam Act 1950, the number of deportations from 1985 till date is slated to be a mere 2,000 odd. Even those deportees are mostly, if not all, pushbacks, which results in the same deportees coming back post-deportation from a border which is completely porous. It will be seen that the Assam portion of the border with Bangladesh is 267 kilometers, out of which 44 kilometers are riverine. We are given to understand that the entire border between India and Bangladesh is roughly 4,000 kilometers. The white paper shows that large portions of the border with Assam are yet to be fenced with double coil wire fencing, making the border an easy place to cross. Also, we are given to understand that most parts of the border with West Bengal and other northeastern states are also porous and very easy to cross. Then, Millards, the court periodically issued directions with regard to the border strengthening. Now, I might just mention over here only, just so that I'm done with these orders. Your Lordships may just note that there is a further order, I'm just drawing your Lordship attention to it, passed by this court on 1st December 2015. 1st December 2015, you will find that order at page 6250, volume 3. It's in the present batch of petitions. And may I just request you to go to page 6256 just for a moment. 6256, volume 3.
Page
6256. Volume 3. What's the index number? Your Lordships have it?
Yes.
Yeah. So, Manoj, I'm going directly to page 6256 and you'll find a reference to our present writ petition 676 of 2014. I'm doing so only to mention that the court records that, look, prima facie, we don't feel Rule 4A of the rules is violative. However, it refers this issue also to this bench. So I'll just read that portion. Writ petition 876 of 2014 has already been referred to the Constitution bench. Nevertheless, we have considered the vires of Rule 4A of the Citizenship, Registration of Citizens and Issue of National Identity Card Rules 2003 in view of the insistence of learned counsel for the petitioners who contends that the authority engaged in the preparation of NRC should not take into account the cases of such persons included in the electoral rolls of 71 who belong to the stream of migrants who came to India between 66 and 71 and who have not been declared as a foreigner and who have not registered themselves. Prima facie, we find that the provisions of section 6A3 read with the proviso to Rule 3.2 of the schedule to the Citizenship Rules 2003 adequately take care of the situation. Rule 4A of the Citizenship, Registration of Citizenship and Issue of National Identity Cards Rules 2003 does not prima facie disclose any such infirmity which would require any orders to be passed at this stage, that is, when the work of the NRC preparation has reached an advanced stage. It is on the aforesaid basis that we decline to pass any order, leaving the entire matter to be considered by the Constitution bench. So I'll just mention that this specific rule is relatable to 6A. I'm just mentioning, if 6A goes, then this rule which is specific to Assam may also fall, and it is before your Lordships. The Assam Accord I have already referred to, so I've read that. But you may just note that it is also separately available. You may just note it at page 460 of volume 4. The 15th August 1985 Accord. It's separately, it's extracted at length in the judgment under reference.
What is the page?
460.
Page 460, serial number 16 of volume 4. Volume 4, statutory enactments. Now, sorry.
Same as that.
Only one interjection. In the last order passed by this bench, my Lord, after noting this, my Lord, your Lordship,
formulated one question.
one question only,
10th of
6A.
January.
NRC is not right now in, my Lord, scrutiny.
It's actually 6A which we have.
Yeah, that's
Validity of 6A, that's the limited.
Our submissions will be around that as well. But we have,
In fact, the points which Justice Nariman had formulated, the 11 points, are really facets of
They are
an
facets
argument.
of
Actually,
6A.
they are actually facets of what they will be arguing.
That's right.
That's why when we met in January this year, we thought we'd just bring it down to one issue.
Positions were, my Lord, compressed in one line. That
Yes.
is whether it is constitutionally valid.
And the ambit of the petitions is therefore 6A.
6A, not
Yeah.
NRC issue.
Yeah. So may I?
You have no issues on you have no issues on the implementation of the accord per se. Because, the act is in purported compliance of the accord.
That's correct.
But actually, the accord is much more comprehensive.
It's comprehensive.
It also
It's a
speaks
package.
about what is required to be done.
Yeah.
And how to take care of the situation,
Right.
what was the situation earlier, how remedial, and what
Right.
how to move forward.
Correct. Yeah.
You have no issues with the steps that are required to be taken, or which is taken but not adequate.
No, I would put it this way. I'll just indicate to you also, sir. The challenge is, and I'll be taking it to the prayers, etc., is directed against 6A and the constitutional vires of 6A. Is it valid or not? We may have a political settlement, but when you enact a law or you bring it in, it must comport with our constitutional norms. That's going to be our basic thrust. Now, you also have situations where a statute which may be valid at a particular point of time may, if the situation that continues to obtain because of non-implementation of other factors under the award, etc., render a provision which may otherwise be valid as invalid because the bargain has not been completed and the very rights which you are required to protect under the political accord have not been protected, and the situation continues on the ground, including violence which continues on the ground. Anyway, we'll deal with that, but I will remain focused on 6A. I think we're all agreed on that in terms of molding the relief, etc. I'll come to that. So now, Manoj, I'm done with
Give
it.
us some idea.
Yeah.
How many people benefited? So it's really two classes. Those who came before 1966
Yeah.
were regularized
There's
and they were
nothing-
granted
I
citizenship.
don't.
Those who came between 66 and
And
25th
71.
March 1971
Yeah.
were removed from the electoral rolls for 10 years. After
Yeah.
10 years,
No, but
they were
that's
restored-
provided you register. It's not automatic.
Right. Provided you
Yeah.
register.
It's not automatic, but
Yeah, it was
subject to
first,
fulfill.
it was a two-step process. First, detection under the 1946 order. Following that, deletion. And after 10 years, restoration. Now, what is the quantum? How many people who had taken the benefit of this prior to 66? And what is the quantum we are looking at of 66 to 71? Post 71, of course, there's a cutoff completely after 20.
71, there cannot be, then all are illegal immigrants.
Right. So what is the quantum we are looking at? I mean, do we have figures on how many people have been given pre-66 and 66 to 71? Because Mr. Devan, one way of looking at it is what is the impact? I mean, and ultimately we have to also look at it in a broader perspective
No,
of the
the
fact
impact
that there was
This may have some
war in
relevance with the
Bangladesh.
delay question also.
That's right.
Because this is some
No,
40
the
years.
impact is
And then
Yeah.
Only apropos your lordship's question, Lord, of course, the official figures will try and get, my lord, as soon as possible. If your lordships can come to volume 4, page 2065.
Volume 4, page 2065.
65. Lord, this is one honorable member in the Rajya Sabha giving the details. So it is details provided by a member. These are not official figures, my lord, but on the left-hand side column, somewhere, my lord, 10th or 15th line from the top,
How do I get to this?
it says the number of entire lots, my lord. Your lordship would get somewhere in the middle, left-hand side, middle, 10th or 12th line, my lord. Before 51 to 1966, your lordship gets it.
29.
My lord, does your lordship get one?
15
Yeah.
lakhs, 39.
May I read? Those who came those who came before 1971 were citizens of East Bengal, and so they cannot be deported. So via media, the number of entire lot who have come before 1951 to 66, we are not concerned with that, my lord, because we are concerned with 66 to 71. But this figure is 15,33,000, and between 1966 and 71 is 5,45,000. These are approximate figures. There may be errors here and there, subject to correction. So the period in which your lordships are examining, that is 66 to 71, according to the honorable member, the figure was 5,45,000.
What about their progenies?
They would become the citizen.
Mr. Baru Islam.
I may just point out. The member was quite familiar with us with this area.
It was from Assam.
From Assam. No, I may just point out, we have placed data of the decadal population growth rates for the state, for all the states of India, including the official government of India.
That's not relevant.
No,
For CA.
No, not for CA, for the point of view, because that is which I will be showing your lordships in my turn, which would corroborate these figures vis-a-vis because there's a natural population growth rate, and then there's what would be deemed to be an excess growth rate, which is highlighted in General Sinha's report and all that assumption that there's a huge so all that we'll point out.
What is this? Influx?
Yes, Ms. Devan. Now, how do you formulate your submissions? We'll go straight now to the heart of the matter.
Sure, I can formulate the submissions broadly, or I may I wanted to read some pleadings of mine, etc.
All right.
And give you the background, and I'll formulate it.
Yeah.
It's essentially going to be a set. Let me formulate the submissions. I'll just formulate them right away, at least for my part, and then there are several supplementary submissions which are also being made. So the first set of of submissions which I am going to project is that as far as Section 6A is concerned, it violates the essential fabric of the Constitution as seen from the preamble. So this is one head of submissions. And here you may just note that we are going to emphasize fraternity, citizenship, and integrity of India. Unity and integrity of India. So these are preambular values. And according to us, Section 6, capital A, completely destroys and undermines these absolutely fundamental values. That's one set. The second set of submissions is with regard to part 3. And here we will endeavor to persuade you that 6A violates 14, 21, and 29. The third set of submissions, broadly, it will be just the point that I make, and I'll take you to those statutory provisions, is that there are political rights. And in that regard, insofar as Articles 325 and 326 of the Constitution are concerned, these are political rights with respect to citizens. And there is a destruction, according to us, or an undermining of these rights as well, of these provisions. The fourth head is with regard to what I will broadly describe as legislative competence, but there will be several submissions which are made on that regard. But there appear to us to be certain, which Justice Nariman in his order has also referred to, that there's a scheme under the Constitution with regard to citizenship, and whether you can have a legislation which is contrary to, in terms of date lines and deadlines, contrary to what is already stated in the Constitution as being the cutoff line for either automatic or some modified this thing without amending the Constitution.
So the legislation is contrary to the date lines.
Yeah, so it's broadly under, yes, quite right. So it's broadly under the competence issue.
Part 2.
Yes, part 2. Of shifting the deadline while retaining what is in the Constitution. And finally, our submission would be that there are overarching principles of democracy, federalism, and rule of law being part of the basic structure. And Section 6A, in the manner in which it operates, might undermine these core values as well. So I'll try and put everything into one of these 5 boxes, but there may be certain other refinements and developments. So this is going to be our broad. Now, may I take you to volume 3, page 2990. I'll just tell you what I'm doing next. I'm reading through certain averments of my petition and the prayers and the relief. So, but from the general, which was with regard to the reference order, etc., I'm now just moving to my particular set of problems, with which is why I came before this court. So, if your lordship is pleased to go to volume 3, writ petition 876 of 2014 is at page 2990. It's item 50 in the index.
You want us to look at the prayers, Mr.
Yeah, so I'll just very quickly take you through a few portions of this. Now, first, please just have a look at the course title, just for a moment, very quickly. So these are a set of bodies. There's the All Assam Ahom Association, the Sutia Jat Sanmilan, Jati Sanmilan, etc. And there's a fuller description which I'll come to because I want to read those paragraphs from the petition itself. And just have a look at the array of parties who are the respondents, and you'll find those at page 2992. So there's, of course, the Union of India, the Registrar General of Citizens Registration, the Election Commission of India, State of Assam, and AASU. Thereafter, you may just note that we have also implemented the various state governments as well as the union territories as party respondents to the petitions, and notice has been served on them, and many of them have filed replies. And this is really with regard to another approach, because one of our contentions is going to be that, look, you cannot have a situation where your cultural rights of one border state get completely undermined and destroyed. If ultimately this is upheld, then there has to be a corresponding duty to ensure that the people are not completely going to reduce persons who are living on a border just by coincidence on the border to a minority or to lose or dilute very, very substantially their political and cultural rights. It then becomes the responsibility of the central government and all the units in the federation to assume some part of this burden. If we are going to welcome people over there, allow them to overstay, not have any system at all by which the persons are required and mandated to be removed, the illegal migrants. So that's going to be one other set, which is why we have put these particular parties also as party respondents. Now, please go directly to page 3000,
Mr. Diwan,
para 3.
you have included all the states and UTs, all the states and UTs.
We have. And so they filed replies. Some of them have in fact gone so far as to say that, yes, we realize this problem. And if there is a direction from the court, we will, we'll comply with it in this regard. So anyway, now, my lords, if your lordship is just pleased to go directly, I'm just giving you a little bit of a description of who I am. And for this purpose, go to internal page 11 of the petition, running page 3000 of volume 3. I'll read a few of these so that you have an idea and a sense. Writ petitioner number 1, the All Assam Home Association, was established in the year 1893. The aim of the organization is to bring political awareness among our home community in the state of Assam and to work for all around development of the Ahom community and to try and solve all types of problems faced by the community. The petitioner number 1 organization also works for the preservation of old rituals and religious customs, monuments and historical sites. It is especially working for socio-cultural economic development. Writ petitioner number 2 was established in the year 1925 with registration number 1929. It's a non-political social cultural community developing organization and works for the unity of the Sutia community in Assam. The Sutia community is scheduled tribe in the state of Assam. Writ petitioner number 2 is also working for the all-round welfare and development of the community. It is also working for the protection and preservation of culture, rituals, customs, land rights, and political rights. Writ petitioner number 3 was established in the year 1978. Its society registration number is so-and-so. Writ petitioner number 3 was formed to preserve and develop the Garo language and culture, to work for research and development of Garo literature, to write and produce the Garo medium textbooks for elementary and secondary education in Assam. It is working for all-round development of the Garo community, which is a scheduled tribe in the state of Assam. It is specially working for socio-cultural economic development and preservation of traditional custom, rituals, old religious activities, and beliefs of the community. Writ petitioner number 4, established in 1955 and is a registered society. It's a non-political socio-cultural organization. The aims and organization is to preserve and develop the Rabha culture and tradition, organize workshops and trainings for the development of Rabha culture. The Rabha community is a scheduled tribe in the state of Assam. With cultural troops, the writ petitioners participated in the Republic Day parade in New Delhi on several occasions. The writ petitioner number 4 is working for the unity and integrity of all communities in the state of Assam. Writ petitioner number 5 is the Coach Rajbonshi Songram Samiti. It is a socio-political organization. The aims and organization is to work for the all-round development of the Coach Rajbonshi community, a scheduled tribe in the state of Assam, including the preservation and protection of culture. Writ petitioner demands self-determination of the Coach Rajbonshi community. The writ petitioner number 6 is so-and-so. The Samiti was established on 2nd February 2007 and its head office is given. The aims of the writ petitioner number 6 is specially working for socio-cultural economic development and preservation of rituals, old religious activity of the Deori community, a scheduled tribe in the state of Assam. Writ petitioner 7, the All Senior Missing Citizens Association. The association was established in 2008. This is our registration number is given, non-political social organization. Object is to foster the spirit of unity and universal brotherhood among the missing community and to create awareness of importance of education, science, economics, technology, industry, sanitation, and literature, and further to preserve the missing religious beliefs and its culture. So-and-so is a missing community, it's a scheduled tribe in the state of Assam. 8 is the All Assam Thai Khamti National Council, socio-political organization, working for the all-round development of the Khamti community, specifically working for socio-cultural economic development, preserving traditions, customs, rituals. Number 9 is the All Assam Scheduled Caste Students Union. Organization was established on 15th February 62, non-political students organization, and was formed to actively fight against all kinds of discrimination, repression, and domination of scheduled castes in the state of Assam, and to work for the rights of the scheduled castes and to further create awareness for socio-political and cultural rights. Writ petition number 10, the Sonowal Kachari Songram Samiti. It's a socio-political organization. So, the Sonowal community is a scheduled tribe in the state of Assam to create awareness about the socio-political and cultural rights amongst members of the community. The writ petitioners are various. There are, you'll also have seen, registered and unregistered societies who have, who have been demanding the determination and deportation of all migrants in the state of Assam who have illegally entered from the erstwhile East Pakistan after the year 1951. The writ petitioners strongly believe that the culture and identity of various ethnic communities in Assam is at threat from the rapid demographic change caused by the continuous and unabated illegal migration from erstwhile East Pakistan and now Bangladesh ever since India's independence. The writ petitioners have at various times raised its concerns through various democratic and peaceful means, creating political awareness and holding various seminars, protest marches, political debates, and regularly interacting with the administrative officers and political leaders. The writ petitioners reserve its right to furnish other details, etc. Now, this was the petitioner's respondents. I'm going to skip. Now, please go to paragraph 16, actually, para 16 on page 3006. I wish to just read paras 16 through till 20. The writ petitioners seek to highlight the state of Assam has already witnessed several ethnic clashes and violence, the scale of which are unparalleled in our history in terms of the loss of human lives and destruction of properties that is left. These ethnic clashes have occurred due to the continuous conflicts and tensions between the indigenous and tribal citizens of the state of Assam and the migrants and refugees from Bangladesh who have migrated to the state of Assam since India's independence and have found shelter in the state of Assam due to various factors, including vote bank politics of the political parties in the state of Assam. It is apposite here to refer to the Nelly massacre and the Bodoland riots of 2012. The Nelly massacre took place in Assam during a 6-hour period in the morning of 18 February 1983 by the Lalung tribes people. The massacre claimed lives of 2,191 people, though the unofficial War II. In July 2012, riots in the Bodoland territorial autonomous districts consisting of Baksa, Chirang, Kokrajhar, and Udalgiri districts and neighboring Dhubri district of Assam have claimed about 90 lives on 31st August 2012 and displaced over 400,000 people. This internal displacement has been variedly described as the largest one since India's partition. A violent demonstration was held at Azad Maidan at Mumbai on 11th August 2012 to protest against the attacks on Muslims in Myanmar and Assam, both unrelated. Over 50,000 people hailing from Northeast India fled from various states of mainland India due to the physical attacks and direct and indirect threats through bulk mobile SMSs and social media platforms from religious fundamentalists. In March 2014, Assam witnessed fresh riots in Kokrajhar, Chirang, and Baksa districts in Assam, which resulted to the death of many human lives. Due to the recent turn of events, Assam now faces threats of religious fundamentalism as never seen before. The writ petitioners state that the escalatory spiral of ethnic conflicts flies out of control because one party perceives itself to be threatened and takes measures to protect itself, thus threatening the other, and on it goes. The writ petitioners respectfully submit that the policies adopted by successive central and state governments and the inaction has encouraged migration and settlement of the large number of Bengali speaking people from erstwhile East Pakistan into the state of Assam. There has been no attempt to ascertain the actual number of the said migrants. and the adverse impact which is the migrant population is likely to have on the local culture, traditions and heritage, scarce natural resources, demography and livelihood, and security of residents of Assam who are citizens on the date of adoption of the Constitution of India. The writ petitioners further submit that unfortunately there's a complete policy paralysis and lack of determination to resolve the sensitivity of this alarming situation that exists today on the ground. There's no clear policy of the government till date and regards to the settlement of the vast migrant and refugee population of Bangladesh who have illegally occupied the lands of acquired property rights in the state of Assam prior to the coming into the force of the impugned provisions of law, that is Section 6A. There is no measure taken till date to check the alarming population growth in the migrant community, nor any steps are taken to see a gradual assimilation of the migrant community into the mainstream Indian culture. The writ petitioners submit that the inaction of the government has put at jeopardy the very existence of Assamese culture, religion, and national identity. There is a simmering belief that the vote bank politics would not allow a permanent solution to the problem. The tribal population of Assam is increasingly feeling more alienated as vested groups have given the ethnic clashes the color of an anti-Muslim propaganda, which is actually an ethnic and economic conflict. The writ petitioners submit that insurrections and intercommunal violence in which religious, linguistic, or racial divisions are a significant factor now form the majority of armed conflicts in the world today. Since the fall of the Berlin Wall in 1989, ethnic conflicts have grown and proliferated at an alarming rate. Examples of ethnic wars, breakup of multi-ethnic states along the lines, and then there are several examples which are given. Now please go directly to paragraph 35. Now these are the, sorry, I should have given the page. It is 3022, internal page 33. Now these are our amendments, and it will give your lordships a sense of our case as far as Assamese culture is concerned. Para 35. The Assamese culture has developed due to cultural assimilation of different ethno-cultural groups under various politico-economic systems in different periods of history. The term Assamese is often used to refer to those who are citizens of Assam. The Constitution of India has defined who shall be a citizen of India, and therefore the reference point for determining the Assamese culture for recognition as a constitutional right has to be the date of adoption of the Constitution of India. It is relevant here to briefly delve into the history of Assam. In the earliest recorded times, Assam was part of the Kamarupa, a state that had its capital at so-and-so, now Guwahati. King Narkasura and his son Agadatta were famous rulers, and during the Mahabharat period, approximately so-and-so, a Chinese traveler so-and-so left a vivid account of the country and its period. Assam was ruled by various dynasties, and those are named, and there was constant warfare amongst the princes until the coming of the Ahom people in the 13th century. Ahom ruled much of Assam from the 13th century until the establishment of British rule in 1838. Their power in Assam reached its peak during the reign of King Rudra Singh. The Ahom dynasty managed to keep the kingdom independent from the Mughal, though the Mughal attacked Assam 17 times. Ahoms, in fact, scored a decisive victory against the Mughal army in 1671. Due to the patronage provided to Hinduism by later-day Ahom kings, many tribes dotting the complex ethnic landscape of Assam were subsumed into the larger Hindu framework, which concomitantly and comfortably coexisted with an emerging Assamia identity. The Burmese invaded Assam 3 times between 1817 and 1819, politically weakening the Ahom rulers of Assam. This set the stage for a British campaign against the Burmese, whom they defeated, leading to the Treaty of Yandabu in 1825. By 1839, the Assam was completely annexed by the British, who included it in a part of the Bengal presidency. The colonial government then established its monopoly over tea. In 1874, Assam was separated from the Bengal presidency, and with Sylhet, it became the Chief Commissioner's province with its capital at Shillong. The British tea planters imported labor from central India, mostly from Orissa, Jharkhand, Bengal, and Bihar, adding to the demographic canvas. The inception of the Assam province came into being after the partition of Bengal in 1905 to 1911. At first, it was carved as a newly joined province of Assam, and East Bengal headed under Lieutenant Governorship, but later in 1911, the East Bengal was reunited with Bengal, and the new province of East Bengal of the East became Assam, Bengal, Bihar, and Orissa. 1905, again, the demographic invasion from East Bengal had started for cheap labor, encouraged by the colonial government. It is recorded that between 1905 till 1947, there was an unabated migration of population from East Bengal, continued to sparsely populated fertile lands of Assam. The 1951 census estimated the number of migrants from East Bengal at around 1.5 million, between 1/10 to 1/6 of the total population of the state. These immigrants and their descendants are neither illegal nor Bangladeshi. It's worthwhile to mention here that in 1532, so-and-so invaded Assam with an army and was defeated by the king of the Ahoms. Those taken prisoners were settled in the region and married Assamese women, losing all their culture, Islamic culture, within a few generations and adopting local customs. In the 1630s, the Muslim saint Shah Milan, also known as Azan Fakir, opened the way for Islamic missionaries by winning the patronage of the Ahom rulers. Between 1910 and 1931, thousands of Bengali Muslim peasants from eastern Bengal, now Bangladesh, came and settled in the state of Assam. Their descendants today have adopted to the Assamese language and identify themselves as Assamese. The Assamese Muslims are well integrated with the rest of the Assamese society. Assamese Muslims are often been in positions of influence within society of Assam and even India. One of the most famous individuals was Fakhruddin Ali Ahmad, President of the Indian Republic from Assam. The petitioners state that the Assamese language is the principal language of the state and is regarded as lingua franca. The population of Assam largely comprised of numerous Assam tribes with their varied customs, languages, tradition, culture, dresses, and exotic way of life. Some of the prominent tribes of Assam are Bodo, Singpo, Santhal, Dimasa people, Karbi, Khamti, Khamyang, Mishing, Nishi, Pake, and Rabha. The tribal communities of Assam have their individual languages, cultural traits, rites, rituals, festivals, folk music, dance, contributing to the richness of the socio-cultural fabric of Assam. Assam, being the home to many ethnic groups and different cultures, is rich in folk music. Painting is an ancient tradition of Assam. Silk weaving and crafts is part of the rich Assamese culture. The institution of Satra is a unique feature of Vaishnavism in Assam, founded by so-and-so, the father of Assamese culture. Institutions like Satara, monasteries, and village Namgarh, prayer houses had profound influence in the evolution and social makeup of Assam society. The artistic oeuvres led to the engendering of new forms of literature, music, theatre, and dance. There are several important traditions, festivals of Assam. Bihu is the most celebrated festival of Assam. The ethnic tribes in Assam have their own festivals. Reference has been made to various studies and articles by eminent scholars on the culture of the state of Assam. The writ petitioners will refer to and rely on the same. The last part your lordship may see is what you had mentioned, which is at internal page 69, page 3058, which is the relief which we have sought. So our primary prayer is a declaration that Section 6A of the Citizenship Act as unconstitutional, being violative of 14, 21, and 29. The second prayer is to declare Rule 4A of the 2003 rules, as well as a notification dated 5th December 2013, issued under by respondent number 2, the Registrar General of Citizenship, as ultra vires 6A. So, assuming 6A is valid, these rules, as you will see when we show you the cutoff date, goes beyond even 6A. Now, please see 3. In the alternative to prayers 1 and 2, issue a writ of mandamus or any other alternative writ or order or direction to the Union of India to forthwith frame a policy in consultation with respondents 6 to 50, which is the states and the union territories, for settlement and rehabilitation across all the states of and the union territories of India proportionally, all persons of Indian origin who came to Assam after 26 January 1951 from the specified territory as defined under Section 6A of the Citizenship Act and further direct that the said policy shall be implemented directly under the supervision and control of this Honorable Court. And then there are various directions with regard to which we have requested regarding complete fencing of the border, steps for process of identification, detection, and deportation of foreigners in the state of Assam in accordance with the provisions of the Foreigners Act 1946, and to constitute more tribunals, issue a writ of mandamus, state of Assam to immediately take steps to remove encroachers from the protected tribal lands created under the Assam Land and Revenue Regulations as amended in 1947, and a mandamus or any other alternative writ set up an independent committee to suggest measures with regard to these encroached lands as well as national forests, etc. So this then is the frame of our writ petition. Now I want to just supplement our the portions which I have already read from Justice Nariman's judgment and the reference order on the magnitude of the problem with certain independent material that we have placed before you and which is now on the record. So to that end, may I request you to go, there is the Brahma Committee, and that notification of the Brahma Committee, your lordships will find in volume 4. Yeah, just a minute. So, Manoj, if your lordship is pleased to go for a moment to volume 4, page 2742. My mistake, 2742, I think. Just for a moment to 2742.
That's internal page 21, I think, is it?
It's internal page 21.
This is the Brahma Committee.
Your lordships have that? Sorry.
Committee of 2017.
That's right, 6 February 17.
30th December 17 looks like.
Oops.
And this is actually Dr. Rohini Kumar Barua,
Yes.
Anil Kumar Bhattacharya, Ajay Kumar Datta, Ramesh Barpatra Gohen.
Your lordship has that? It's
Yes.
6 February 17 or? Huh?
30th 17.
No, sorry, which is your lordship on page 2742?
Yes, but it begins at page 2722.
Yes, so I'll come to that, but that's the report. You're absolutely right.
Yeah.
That is the report. I'm taking you to the notification which set up this committee first.
But that is not 2742. 2742 is internal page 21, I think.
Correct, 21. At the foot of the page.
Where does the notification begin actually?
1.17, your lordship has para 1.17?
Yes.
So just below that. Does para 1.17 begin with a positive step of the state government of Assam?
That's correct.
Chief Justice,
Yes.
your lordship has that.
Yes.
Correct. So then, if I may just invite attention, just a few lines below that.
This was constituted by the government of Assam.
That's correct. I thought I'll just point that out. 6 February 2017, orders of the government of Assam. The governor of Assam is pleased to constitute a committee with the following members for suggesting measures, including modifications in ALRR 1886, other land laws, government circular, and land policy for ensuring protection of land rights of indigenous people in the state of Assam. And your lordships will notice that it's under the chairmanship of Sri Hari Shankar Brahma, IAS, former Chief Election Commissioner. And then, as your lordship correctly said, the members include Rohini Barua, etc. So this is the notification establishing it. We need to go to the subsequent notification. Now please go to that same report which your lordship correctly noted begins at 2722, correct? Opens at 2722, the final report. And here, may I take you to page 2731. Your lordship said para 1.5. Part of the report.
1.5.
1.5.
Observations of CS.
Correct. So I'll just read that. Observations of Shri S.L. Shakdar, former Chief Election Commissioner of India. The basis for the anti-immigrant bias had been set by Shamlar Shakdar, the then Chief Election Commissioner of India, who told a conference of election commissioners across India in 1978 that he was alarmed by reports, especially from the Northeast, that foreigners were being included in the electoral rolls. Mr. S.L. Shakdar commented that in one state, Assam, the population in 1971 recorded an increase as high as 34.98% over the 1961 figures. And this increase was attributed to the influx of a very large number of persons from the neighboring countries. The influx has become a regular feature. I think it may not be wrong assessment to make on the basis of the increase of 34.98% between the two censuses that the increase that is likely to be recorded in the 1991 census would be more than 100% over the 61 census. In other words, a stage would be reached when the state would have to reckon with the foreign nationals who may probably constitute a sizable percentage, if not a majority of the population of the state. So this was the Chief Election Commissioner who had made this observation. Now please have a look, if your lordships would. Yes. And here, this is back to the Nariman judgment. Yeah. Where do I get that? 1385. But which is the portion? But I haven't got it. That I have. That we've read, no?
Yeah, but you wanted to read this part also.
Seven three one of volume 4, internal page 10. completed para 1.5, which was on page 2731, correct?
Yes.
The observations of the former Chief Election Commissioner, Shri S.L. Shakhtar. Now, may I request you to just go down to the next paragraph, 1.6. Memorandum of Lieutenant General Retired Shri S.K. Sinha, the then Governor of Assam, to the President of India. Lieutenant General S.K. Sinha, the then Governor of Assam, in a report on illegal migration of Assam submitted to the President of India on 8th November 1998, mentioned that the unabated influx of illegal migrants from Bangladesh into Assam and the consequent perceptible change in the demographic pattern of the state has been a matter of grave concern, which threatened to reduce the Assamese people to a minority in their own state, as happened in Tripura and Sikkim. He further stated that the Bangladeshi illegal migrants posed a much greater threat in Assam than any other state, and if the infiltration was not effectively checked, the infiltrators might swamp the Assamese people and might sever the northeast landmass from the rest of India. Some of his observations are as follows. A. Bangladesh census records indicate a reduction of 39 lakh Hindus between 1971 and 1981 and another 36 lakhs between 81 and 89. These 75 lakhs, 39 plus 36 Hindus have been obviously coming to India. In 1970, the total population of East Pakistan was 7.5 crores. But in 1974, it had come down to 7.14 crores. On the basis of a 3.1% annual population growth of that period, the population of 1974 should have been 7.7 crores. The shortfall of 6 million people can be explained by large-scale migration. Muslim population of Assam has shown a rise of 77.42% in 1991 from what it was in 1971. Hindu population has risen by nearly 41.89% in this period. Muslim population of Assam has risen from 24.68% in 1951 to 28.42% in 1991. The much higher percentage of growth of Assam from 1911 to 1971 over the All India and Bangladesh figures indicate migration into Assam. Then please go to paragraph 1.8.1, which is on the next page.
The only thing caveat which we may have to have is that these were inputs to the committee. I'm not sure whether these are authentic figures, whether they are accepted by the government. Figures of the government of India, our census, we can safely go by. There's no difficulty. But something which is an input to the committee for us to proceed as a constitutional court, on those, somebody may say these figures were not right. Obviously,
no, I understand, but
Lieutenant General Sinha submitted it, so he sent it with a great deal of responsibility. But accuracy, we don't know. I mean, a broad trend, yes, it may convey a broad trend, but the specific figures, I'm not sure whether that.
Yes,
it would be safe to rely on.
He is, I think, Your Lordship may take it as a trend. Your Lordship may take this as a trend, but it's an important trend. Now, please see, for our purposes, if Your Lordship is pleased to go to para 1.8.1 on the next page. Open Indo-Bangladesh border, unrestricted infiltration and encroachment on Char and other lands of adjoining districts. The most serious threats to the land rights of indigenous people of Assam, more precisely to the very identity of indigenous people of Assam, comes from the unabated mass infiltration from the landmass now comprised in Bangladesh through the wide open Indo-Bangladesh international border versus Assam, Meghalaya, Tripura and Mizoram. The fact is that a predominant majority of people of doubtful origin occupied the vast Char areas under the explosive growth rate of population. There are few other districts like Barpeta, Bongaigaon, Darang, Dubri, Golpara, Hailakandi, Karimganj, Morigaon, and Naugaon, which are most seriously affected and have contributed largely to changing the demographic pattern of Assam. In this background, the land rights of indigenous people, as also their identity, are at stake. The conclusion is obvious that in case no effective constitutional, legal, and administrative steps, including sealing off of the Indo-Bangladesh border and detection and deportation of illegal immigrants are taken, the indigenous people are bound to be reduced to a landless class of people and to become foreigners in their own home. Then please see para 1.9, graphic depiction of the decadal population growth of Assam in India. It will be seen from the table given below that the population growth rates of Assam have consistently been higher than those in India as a whole since 1901 up to 2011. Further, the index of density of population of Assam has been consistently higher than that of India since 1971 up to 2011, except that of 1981, which was at a level of 230:230, as this figure was not based on decadal census but was only interpolated. What must be remembered is that the relatively lower population density of Assam prior to 1971 compared to India had later not only caught up with but excelled those of the Indian average density. The higher density of Assam's population can be attributed to the higher growth rate of the Muslim population, particularly in the immigrant-dominated districts. Tables 1, 2, and 3 below respectively show the population trends in Assam and India, religion-wise, population growth as per the census report of 2011 and the districts with religion-wise majority of population. So there are further inputs on the basis of the census figures which are available. And if your lordships would now move further down to 1.14.
How many districts does the state have?
How many districts in this state?
Present 34.
34.
Present.
34.
There is some reduction last month. We are bringing it down to 31.
31.
31.
Some
The
districts
learned
may have been merged.
is here.
They may have been merged, etc., right?
Yes.
Amalgamation of the district.
One point one. Yeah.
1901, some less than 8%.
Table 1.1 on page 2733.
1 point.
1.
Table.
So you'll find the years which are given in 1901 onwards, census years. And please see the population of Assam, and as against that, the population of India. Then the percentage decadal variation is indicated in the next column. And then please see the density. Now in 1901, you will find that density as far as Assam is concerned is 42 per person per square kilometer, whereas the national density was 77 persons per square kilometer. Then please have a look at 1951. By now it is 102, but it is still below the all India density, which is 117. And then if you see the 2011 figure, the density per person has now gone up to 398 persons per square kilometer and exceeded the national figure of 368 persons per square kilometer. So from being well below in 1901, there has been a considerable increase. And as we saw from the committee report, they have said that please ignore 1981 because that was an extrapolation. But for all the other years, your lordships will find that 91, 2001 and 2011, the density far exceeds the national figures. Yes. And your lordships will see that the source at the foot of page table 1.1 is Census of India, 2011. Your Lordship may just see the foot of, sorry, not foot, but page 2733, just below foot of table 1.1. The source for those figures is indicated as being the Census of India, 2011. Show to me. Now, if your Lordship would go to 1.14, paragraph, on page 2741.
Actually,
Yes.
what, I mean, just to analyze that table, since
Yes.
it's based on the census.
1.1.
Interesting, yeah, 1.1. Something very interesting emerges from that. If you see the population, we'll not go by the percentage increase. We don't know it. We have only the percentage decadal variation. 1901, the total population is 33.
Yes.
11, it becomes 38. Look at the rate of growth. 5. 30, 21, 46. 31, 56. 41, 67. Slight is about a 10 lakh increase. Then again 51, 80. Between 51 to 61, the population really jumps from 80 to 108, almost a 28 lakh increase over 80 lakhs, which is almost a 25% increase. Then see what happens between 61 to 71. It increases from 108 to 146. That is a 38 lakh increase over 108, which is again almost 33% increase. Then 71 to 81. This is a crucial period for our purposes because that's when the liberation takes place, the war, the 25th March cutoff. So 71, it is 146, right? And then 81. So 61 to 71, it increases from 108 lakhs to 146 lakhs.
That's the crucial period.
Yes. And 71 to 81.
That's a projection.
It increases to, it's a projection, is it? Interpolation,
Yes.
they say. It is roughly, it increases again by 34 lakhs to 180. 81 to 91, it goes to 224. That is a 44 lakh increase. Again, 91 to 2001, it increases by 40 lakhs. And then 2001 to 2011, it increases to 312, which is almost like a 44 plus 12, 56 lakh increase. At the same time, Mr. Diwan, we have to be very careful. We are not in this case, I mean, as a reference to the Constitution bench, we are not really looking at what is happening today or post the 1985 amendment, the post the accord and the amendment to the of Section 6A. We are looking specifically at a period which is frozen in time, right?
I would say you look at both because if I'm...
No, we can't, well, we cannot adjudicate upon the validity of that Section 6A on what has happened subsequently. Because assuming you're right, we'll put it in your favor.
of the statute.
We will put it in your favor that there has been a sudden increase in the infiltration according to you, post the amendment as well. But will that have an impact on the validity of the amendment itself?
No, I'm not for a moment suggesting that.
Right.
It's not my submission. My submission essentially is that according to us, the amendment doesn't stand for the reasons which I have broadly
You have
indicated.
now shown us the
But
cultural,
on this aspect,
the cultural identity
yeah,
that you have
on-
formulated your. We'll have
But
to hear
on
the
this
other side.
aspect, I think this is, sorry.
You can't test it.
This may be a facet with regard to our arguments on identity, on cultural rights, on indigenous peoples, etc. And the dilution, because, and ultimately it will translate into a complete dilution of your political rights as well. So what we are saying, and eventually this, your Lordship sees that this report is with regard to land and what is happening with regard to the extensive encroachments. Sorry.
Suppose the amendment by the legislature was, we're giving you a hypothetical.
Yeah.
Suppose the amendment of the legislature was that anybody who has entered into Assam after 25th of March 1971 will for 10 years not deleted from the electoral roll. After 10 years, they will get citizenship. Then perhaps it would have been a completely different scenario because then you are encouraging illegal infiltration by saying that, look, you come here for 10 years, you will not be in the electoral roll and thereafter you get citizenship. That's not the amendment which the legislature
So
has.
this is what the amendment which the legislature has done. We'll see the provision, of course.
What
they've
it
done,
does is freezes it at 71.
it freezes it at 71 and incentivizes people to
One
remain.
It's a one-time measure.
No, I'm not saying it's not a one-time measure, but look what's happened over here. What's happened over here is twofold. First of all, there has been nothing subsequent to that because we've seen the figures, etc. Even post 1985, the influx continues. But today, as a result of not enforcing the law, which was that illegal immigrants have to be identified and appropriate action taken in accordance with law, that has been completely given a go by, and this is being used as some sort of a shield. The result, so my primary point is that this provision itself is bad. You could not have, having regard to the constitutional mandate and your obligation as the state to protect my cultural rights, to allow a continuous dilution all the way up to when the statutory provision was introduced in the first instance. And because that itself resulted in a tremendous dilution, and then it has a multiplier effect because by recognizing these people, one, by not taking any action which you are required and obliged to do, because they are completely in default as noticed by this court in the reference order judgment itself, what is left of my cultural rights? What's left of my land? What's left of my economic rights? And you're issuing electoral cards over here and giving people a right to vote. So how is that to be countenanced? I mean, this is the essence of this kind of demographic invasion. And therefore we say that, look, if you're so welcoming, please don't burden the state of Assam. You have so many border states. Where's the question of having a special regime only for Assam? Then you have this regime for everybody. You may have some historical justification for the accord. Well and good. But I'm sorry.
According to you,
Yeah.
consequence does matter.
Yes, it does matter. Effect of the order, effect of the law.
On two broader grounds. One
Right.
is, according to you, it will facilitate the another set of illegal migrants to come, number one.
Yeah.
Number two, the consequence is that, one that group becomes larger,
Yeah.
it affects.
Yes.
So to that extent, you say
Yeah.
that consequence will have to be written to the
And
statute. That's
future
what it says.
generations. You see, it's very, if you absent a machinery, let's just keep just suspend the submission with regard to that this datum line is bad. Keep that aside. The moment you have a situation where you are recognizing a particular set of people and conferring upon them citizenship automatically, which according to us ought not to be done, what happens as far as the next generation is concerned? So you are actually cementing something which has happened in a illegal manner.
So one more thing which we'll have to bear in mind,
Yes.
Mr. Diwan, is that if the legislature, if the parliament were to merely grant amnesty to a group of illegal immigrants, that
Yeah.
would be a very different situation.
It would be a different.
It would be a very different situation. But we can't deny the fact that 6A
Yeah.
was enacted at a point of time which
Yeah.
is deeply connected to our history, namely
Right.
that India had a very vital role, if I may use that expression, in the creation of Bangladesh, because we were part of the war as much as Bangladesh was.
We were.
The immigration which took place, Parliament seems to have proceeded on the basis that the immigration which took place cannot be regarded purely on the footing of an illegal immigration, but it was something which was really a humanitarian aspect of what the atrocities which were being committed on the population in East Pakistan, which is why India intervened. The war took place, there was a liberation, Bangladesh was created.
Correct.
And therefore, this was not just looked at by Parliament from the perspective of an illegal immigration, but something which is deeply interwoven in our own history of conflict and the liberation of Bangladesh. So it seems to have been on that ground. Therefore, we are
But
not
that
saying
argument, that submission of your lordship falls completely in my favor, and I'm obliged for this observation because when we examine the cutoff dates, as far as people who have come after the atrocities, as far as Bangladesh is concerned, this extends no protection to them at all. At all. That's why, sorry.
Undoubtedly, therefore, there are two parts of your petition.
Yes, that's correct.
One is section 6A,
Yeah.
and the second, as Brother Suryakant, Brother Sundaresh also said,
Yeah.
is the failure to implement the law post the 6A.
Yes.
That's a separate issue. But what has been referred to the Constitution bench is the first, namely the validity of 6A. See?
No, but of course, the validity of 6A, but assuming 6A is valid, and it's been held to be reasonable, etc., and it survives the constitutional test. I'm sorry.
Your first challenge is that, 6A itself as a whole should go.
Go, yeah, that's my primary
What
challenge.
Chief is trying to
Yeah.
tell you is that, could it be compartmentalized in a particular way? Could that
Yeah.
be, is it your case?
Yeah,
Let us assume that we uphold 6A.
yeah,
What extent the rights can be conferred?
yes,
It can be now, can it be, that's why the question is put to you.
yeah,
Whether they can be taken as a citizen per se, giving all rights
right.
to them, much to the detriment of others, or it could be a curtailed right. Just
Yeah,
think,
all right.
think aloud, just
Yes,
what I want to say.
yes.
We'll come back. Discharged for the day because this matter now is completely on board.
आपका यहाँ की है ना?
Yes, Mr. Devan.
Because I was on the
Page
last part, the last part,
271, population trends in Assam and India.
Brahma Committee report.
Yes, now we are on the
So I'm just about to conclude that with the last para which I wish to place is on page 2741 of volume 4, and it is para 1.14.
Yes. What is the date of the Brahma Committee report? 2017, right?
December 20.
30th December
December
17. So para 1.14. Protection of indigenous people's land rights is linked to solution of the foreigners' issue of Assam, implementation of the Assam Accord 85. At the moment, the gravest threat perceptions of the indigenous people of Assam to the safety and security of their land rights, and in fact of their very identity, comes from the surging, unchecked infiltration from across the Bangladesh borders. Protection of land rights of the indigenous people of Assam is, in fact, inextricably linked to the protection of their identity and the solution of the problem of foreign nationals issue gripping Assam for the last 7 decades of independence. The committee feels and recommends that protection of land rights of indigenous people of Assam pre-envisages implementation of the Assam Accord 1985, that is, 1. Sealing of the Indo-Bangladesh international borders via Assam, Meghalaya, Tripura, and Mizoram for checking fresh arrivals of illegal immigrants, as also for number 2, detection and deportation of the existing foreign nationals by signing a repatriation treaty with Bangladesh government, and further for correction of voters list by deleting the names of the foreigners. In other words, full implementation of the Assam Accord as inescapably to be put on a priority card. So I've relied on this essentially to, again, indicate the background facts which have been noticed by this particular committee in so far as the various infiltrations, etc., are concerned. Now, the next document that I wish to point out is the 175th report of the Law Commission of India, which you will find in volume 4 at serial number 52, page 3092. Yeah. So please have a look at this, the context. Your Lordship is pleased to go to page 3093. This is the cover letter by the Chairman, Justice B.P. Jeevan Reddy, on 21st September 2000. I am forwarding herewith the 175th report on the Foreigners Amendment Bill 2000. The subject was taken up in pursuance of a reference made by the Government of India on 16 February 1999. Prior to it, certain amendments were mooted. Foreigners Amendment Bill 1998, introduced by the Rajya Sabha by Home Minister Shri L.K. Advani, the Parliamentary Standing Committee on Home Affairs felt that the government should undertake an in-depth study regarding the efficacy of the proposed amendment in checking infiltration of foreigners from across borders. The committee favored a holistic approach in dealing with the acute problem of infiltration. Various suggestions were made before it and included inter alia the desirability of summary trials, setting up of special courts, making grant of bail more difficult, etc. The matter was referred to the Law Commission. The Commission has considered the relevant material, including the reports and views of the states and union territories regarding their experience in the implementation of the provisions of the Foreigners Act 1946 and other cognate statutory enactments. While dealing with the issue, the Commission had to choose between two options which were available. The first was to recommend a comprehensive act repealing the existing legislations and rules and orders, etc. The second option was to recommend amendments to the existing legislative framework. Instead of codifying the entire law concerning the foreigners, the Commission chose the second option of recommending incorporation of new provisions in the Foreigners Act so that it may make it more effective enough to meet the main problem confronted by the country today, namely illegal migration without interfering with the existing legal framework. The Commission is of the view that the problem of illegal migration from neighboring countries has to be tackled seriously by providing a machinery for the effective and speedy detection of illegal entrants. The function for determination whether the person is an illegal entrant or not is proposed to be entrusted to immigration officers whose orders shall be appealable, etc., etc. Now here, my lords, the point which we are emphasizing, and here your lordship may go straight away to paragraph 3.2, which you will find at page 3100. Since the liberation of erstwhile East Pakistan, the influx, 2.1. May I just take your lordships back to paragraph 2.2 for a moment? Where is that? Okay. 2.2 on page 3097. The problem has attained gigantic proportion, as is evident from an estimated population of about 18 million foreigners living unauthorizedly in India. This has aggravated the employment situation and has distorted the electoral rolls in some states. The undesirable activities of foreigners, including smuggling of narcotic drugs, spreading terrorism and other such activities. It is therefore of utmost importance to devise foolproof administrative measures such as border fencing, modernized electronic surveillance system, as well as effective legislation to deal with the menace. The present study is aimed at examining the existing legislation and suggesting appropriate revision to deal with the issue more effectively. Then para 3.2 on page 3100. Since the liberation of erstwhile East Pakistan, the influx of migrants from Bangladesh has remained unabated and has acquired frightening proportions. There is no realistic estimate of these migrants in India. In fact, no census has been carried out to determine their number. According to the Ministry of Home Affairs, the total number of Bangladeshis illegally residing in India is estimated at 15 to 18 million, and every year at least 3.5 lakhs or more people are infiltrating into the country. On the basis of theoretical extrapolations, the number of illegal migrants in border state has been estimated to be 5.4 million in West Bengal, 4 million in Assam, and 0.8 million in Tripura. It is evident that the number of such migrants is highest in the state of West Bengal. These migrants have spread out to other parts of the country. In Maharashtra, their number is estimated at 0.5 million, in Rajasthan 0.5 million, and in Delhi 0.3 million. These figures are mind-boggling and alarming indeed. India, with its own unmanageable population, is hardly in a position, I think, to take upon the additional burden. Then please go to para 3.5. One of the major causes of the aggravation of the problem of illegal migration, especially in the border states, has been the crisis of identity and absence of proper mechanism for the identification of illegal migrants. The available legal framework has failed to curb the illegal migration. That apart, the illegal migrants continue to stay in India with impunity on account of rampant corruption in rank and file of the enforcement agencies. One of their prominent destinations is Mumbai. Another cause of illegal migration is the clandestine cross-border trade between India and Bangladesh, which is estimated at $5 billion. This is 3 times more than the official trade. The trade has created a network of agents and middlemen working in connivance with authorities on both sides of the border. Thus, strong vested interests also appear to be behind the illegal migration. Further, the trade between two countries has the backdrop of cultural and ethnic ties. In most of the cases, the entry of migrants is surreptitious and they easily mingle with the local population due to ethnic, linguistic, religious, and physical similarities. Their identification is extremely difficult. This has resulted in alteration of demographic composition in the border districts of several states. The bordering states have recorded a high rate of population growth. It has been reported that in case of Assam, there is a higher percentage of rate of population growth in comparison to the national average. There is evidence that many of the illegal migrants have acquired ration cards, obtained various jobs, and got enlisted in electoral roles by suppressing their identities with the help of local touts, unscrupulous officials, and politicians. Impact of illegal migration. The illegal migration has strained the country's economy generally and especially of the border states. The illegal dangerous dimensions affecting the security of the nation as a whole and especially of the northeastern region because of its proximity with Bangladesh. There are reports of large-scale clandestine movement and smuggling of all kinds of articles by such migrants. Local inhabitants of these bordering areas are under constant fear of losing their identity as they have been reduced to a minority in their own state. This has given rise to various movements and violent agitations, especially in the northeastern areas. The problem has economic implications for the local people and security implications for the country as a whole. Then your lordships may see, yes, so these were essentially the paragraphs that I wanted to highlight from the Law Commission's report. Now, the next document is a study which is authored by Dr. Bhupendra Kumar Nath and Professor Dilip C. Nath. And your lordships will find that again in volume 4. Index number is 48. And it is at page 2708. Bhupen Kumar Nath and Professor Dilip C. Nath. So this is from the International Journal of Scientific and Research Publications, Volume 2. The citation is at the top. The title of the paper is The Change of Religion and Language, Composition in the State of Assam in Northeast India, a Statistical Analysis since 1951 to 2001. Now, if we just first see the abstract and then I'll read certain portions. The aim of this study is to examine the change of population composition in terms of religion and language in the districts of state of Assam in Northeast India during post-independence period. The analysis is based on district-level census data of Assam during 1951 to 2001. The result shows that the proportion of Muslim population has been rising rapidly in some districts, whereas the Hindu population is declining and losing their share in all districts of Assam. The change of religious composition has been projected by using polynomial curve fitting, and it is found that Hindu and other religion may become a minority in Assam after 2040 in comparison to the combined proportion of Muslim and Christian population. The growth of various language-speaking population is also analyzed, and it is observed that the proportion of Bengali-speaking population is also rapidly rising, but the proportion of Assamese speakers are declining in all the districts of Assam. To investigate the impact of cross-border migration, the growth of the Muslim population in Assam and Bangladesh in this study. Then, Milords, I'm reading a few paragraphs. Initially, the introduction. Religion is one of the most basic socio-cultural characteristics of a society. Different people, the growth and decline of populations and changes in the relative balance between various groups of religion within a population play a crucial role in the rise and fall of nations and even civilization. On the other hand, language is the most important medium of human interaction. The demands for more autonomy, separate states based on language, not only challenge and threaten the political stability of a country, but also very often lead to ethnic conflicts. Northeast India is surrounded by the border of 4 countries, which are Bangladesh, Bhutan, China, and Myanmar. Though they are separated by political boundary, but they have a cultural affinity in both sides of the border. Therefore, it's important for us to know the changing demographic patterns to make an informed judgment about the cross-border migration and strategic pressures that India is likely to face from its neighboring countries in the near future. This paper examined the changing trend of population composition in terms of religion and language in Assam and all districts during the post-independence period. The change of religious composition has been projected by using a polynomial curve fitting. Moreover, to investigate the impact of cross-border migration on religious change, the growth of the Muslim population of Assam and Bangladesh is also compared in this study. The Census Organization of India is the only instrument that collects the individual information of various religions and language. In this study, the religion and language analysis based on district level census data of Assam during 1951 to 2001, the religion data of Bangladesh from 74 to 2001 has been collected from the publication of the national series, and those details are given. Now, my lords, down that same column, about 15 or 12 lines from the bottom, right-hand column. It is therefore important to analyze the changing demography of different religious groups in Assam. According to the 2001 census, the various religious groups living in Assam and India respectively are 64.9 and 80.5% Hindu, 30.9% and 13.4% Muslim, 3.7% and 2.3% Christian, and 0.5 and 3.8% other religions. It is seen that the proportion of Muslim population in Assam is significantly higher than that of the country as a whole. Strikingly, Assam occupies a second position after Jammu and Kashmir in terms of the proportion of the Muslim population in the country. It is seen from Table 1 that during 51 to 2001, the Muslim population increased by 6%, whereas the Hindu population declined by 7.2%. The percentage change of Christians and other religion during this period are 1.7 and minus 0.5% respectively. This significantly high growth of Muslim population in the state may be due to the consequence of large-scale Muslim migration from Bangladesh and also the prevalence of high birth rate. As a consequence of the slow improvement of socio-economic conditions amongst the Hindus, the natural growth rate of the population amongst them has declined to a great extent from this great extent in the state during this period. So far as the growth of population during 51 to 2001 at the district level is concerned, all the districts witnessed a very high growth of Muslim population during the growth of population than the growth of other religions. The proportion of Muslim population in undivided district Kamrup, so-and-so, so-and-so, and so-and-so has increased by 6%, 8%, 10%, and 7% respectively. But in Lakhimpur, Sibsagar, and UM and NC Hills district, this growth of the Muslim population during 51 to 2001 is only 2%, 1%, and 2% respectively. The undivided district of Golpara, Kamrup, Darang, and Naugam are in continuation of the eastern border belt of high Muslim presence and growth. The undivided Kachar district also falls near the border of Bangladesh and showing high Muslim presence and growth. On the other hand, in almost all districts of Assam and in the state as a whole, the Hindu and other religions declined during 1951 to 2001. In a similar way, the percentage decline of Hindu population in so-and-so are 6%, 11%, 10%, and 8% respectively. But in Lakhimpur, Sibsagar, and UM and NC Hills district, this decline of the Hindu population during 51 to 2001 is only 2%, 3%, and 0.5% respectively. The percentage increase in the Christian population from 51 to 2001 in all the districts are 1 to 2% only, except undivided so-and-so hill, which is 9.1%. A major reason behind the growth of the Christian population in Assam is the intense movement of conversion towards Christianity. The high growth of the Christian population in Assam is mainly due to conversion of scheduled caste and scheduled tribes to Christianity. Table 2 represents the district-wise percentage of religion in all 23 districts of Assam during 71 to 2001. According to the 2001 census, the percentage of Muslim population in some districts like Dhuburi 74.3, Barapeta 59.4, and so on have occupied a dominant position. But out of 23 districts in Assam, the 17 districts are Hindu dominant, whereas the proportion of Hindu population, is more than 50%. 10 minutes, I'm going to skip. And please go to page 2711.
Mr. Diwan.
Just the right-hand side. Yes, I'm sorry.
This data in this article, the instructive, it covers the entirety of the period. It covers the period which is prior to the Section 6A operation.
You're right.
Which is prior to 1966. It covers 66 to 71, and it covers 71 and thereafter, almost till 2011. Now, we are on the constitutional validity.
Yes.
We will have to see whether the impact of Section 6A was such that between 1966 and 1971, the operation of 6A, to test your argument, led to a radical change in the demographics of the state so as to affect the cultural identity of the state of Assam, because that's the core of the argument. Now, post 71, this article seems to suggest that the increase in the rapid increase in the numbers of a particular community is suggestive of increasing infiltration.
Yeah.
That has to be dealt with, of course, by a very strict enforcement of the law. Insofar as 6A is concerned, 6A is not a question of law enforcement. 6A, we are testing pure validity.
Yes, I agree.
So, in that sense, is there any to indicate that the impact between 66 and 71, because the migration which took place between 66 and 1971 was directly impacted by a provision like Section 6A. Incidentally, 6A comes on only post 85, post Assam Accord.
That's not really how
So
it's worked out.
somebody who was coming in between 66 to 71 had no aspiration or expectation that they're going to be granted citizenship. They came in. Now, where is there any material to indicate that this was really affected by 6A?
I would just suggest
So the committee, the second committee which you had given us, the report, which was the Brahma Committee report.
the Brahma Committee.
Para 1.14, the Brahma Committee report, in fact, said that please implement the Assam Accord completely.
Correct.
Because Brahma Committee said, the Brahma Committee didn't say go behind
measures.
Go behind that part of the Assam Accord, which conferred citizenship on that group of people who came between 66 and 71. They are saying implement the other provisions, strict border fencing, detection of foreigners, deportation of foreigners, deletion from the electoral roll,
Establishment of more tribunals.
establishment of more tribunals, giving teeth to the purpose of the law to detect illegal infiltration from any other country and deportation of those persons. That is what Brahma Committee. Brahma Committee also doesn't say that go back on the Assam Accord. That was not really the.
I'm not arguing that, Manoj. It's a political settlement. If someone has a political settlement,
Right.
good luck to them, and let's hope that
But
it
this
gets settled.
But statute has only implemented the political settlement.
Yes, but it must, the statute, the political settlement gives no immunity to the statute. The statute
Absolutely
must
not.
follow the test of the constitution. If it is constitutional, your lordships will uphold it.
But
If
then-
it is unconstitutional, equally the court will strike it down. And of course, sorry.
But to test your argument, there is no material before us to indicate
Yeah.
that the impact of granting certain benefits to citizens who came in between 66 and 71 was so great that the demographics or the cultural identity of the state was affected by that the inflow
No,
in
it,
those 5 years.
first there is material, because all of this is that material. But I am on another point.
Post 71, you need not labor because there, in fact, that's your petition, which will, of course, that's the subject matter of the petition, which will be dealt with by the regular bench. On what are the steps which the government is taking to curb illegal infiltration? That is
Well,
the secondly
first of all,
more.
why 66? Why before 66? What you find from these statistics is that there is a huge number of people who are coming even prior to 1966. Now, the question I ask myself, because your lordship is obviously ahead of the curve, but I am asking myself, why should Assam suffer in this manner? Do you have this for West Bengal? Do you have it for any of the other border states? What is this type of provision which you say that in Assam, if you are there and if you come and infiltrate through Assam, you settle down and you remain over there? I mean, I can understand the uniform law which you have. So keep this political settlement alive. That, of course, everyone must be encouraged to settle their disputes. And if you can have a mediated settlement, nothing like it. But eventually, if you are engrafting a law, then the law has to be first and foremost across the country applicable. Number one, across the country for all states. Number two, surely if the border states form a separate class, then it must apply to all border states. Here what you are doing, and which I am going to show your lordships the effect and impact is, you are encouraging people to stay on in Assam, remain there for a period of 10 years. And why Assam? Why 66 for Assam? Why not for other parts of the country? So what you are doing essentially is, this is invidious discrimination.
There again, the burden will lie on you to show that the extent of the infiltration between 66 and 71 in Assam.
I am saying 66 itself is bad.
Or was comparable to the infiltration in other states.
No, it's not for me to show. I'll just indicate. If I'm not, it's not for me to show. The moment I show, and that is apparent facially on the document or on section 6A, because 6A is applicable only to Assam and no other part. See, this is very important. You are singling out one unit from the entire federation. And you are making a special set of provisions over there, which are destroying my cultural rights and my identity. By heaping me and by protecting people over there, notionally, number one, and thereafter, as your lordships have seen from these figures, on a practical ground reality, where the percentages are just soaring. And then you have a second generation and a third generation. So, I'm sorry, yes.
The initial burden of proof lies on you because you are challenging constitutional validity.
So the classification itself is bad. I agree.
You must therefore show two things.
Yes.
That so far as Assam is concerned,
Yeah.
for the purpose of determining the quantum of illegal infiltration,
Yeah.
Assam was similarly situated as regards as compared to other states like West Bengal, Tripura, the other states, Mizoram, so on and so forth. That is a result of 6A.
I read that Law Commission report which gave those figures on the basis of census figures with regard to infiltration or whatever illegal migrants in other states as well.
Assam was much higher. Therefore, Parliament, if the quantum...
No, just have a look. I think West Bengal may be higher. Just have a look at that.
If the impact is greater in a particular state,
Sorry?
Parliament can always choose degrees of evil and then legislate. We've always allowed an under-inclusive legislation by Parliament.
It's not under-inclusive. What you are doing over here. Sorry? Let us see that page. Law Commission.
That well, you should have applied 6A to West Bengal. You should have applied.
No, that's not my argument. That's not my argument at all. My argument is very simple. I mean, there are several arguments, but one amongst those arguments is with respect to Article 14. And my submission with respect to Article 14 is that we are people, plus we are living. I'm a community. That's why I spent a little time reading the description of whom I represent. I represent a large number of communities which have been living in Assam and who are enjoying culture and want to develop and continue to enjoy their culture.
Because now, when we deal with any matter challenging the constitutional validity of a statute, we begin with a presumption of constitutionality.
I think that's
very
fair.
Well settled.
That's fair.
But we also give Parliament the latitude to recognize degrees of evil. Evil in a sense, I'm using it not in a pejorative sense.
Right.
Parliament can identify the degrees of wrongdoing, the degrees of evil, the degrees of the problem which it wants to.
You're right.
Parliament does not have to legislate with respect to everything to legislate with respect to something. Now,
this is far more important, but please, let's just
respect to Assam. You can certainly.
Well, we are not dealing over here with some classification under a taxing statute or something. We are dealing with citizenship. We are dealing with political rights. We are dealing with issues of tremendous importance, not only for the current generation, but for future generations.
Undoubtedly, yeah.
And therefore, I believe that there will have to be a very strong justification, which is furnished by the state, by the government, in support of this particular stand. It's not enough to say that, look, I had an Assam Accord, a political settlement, and therefore I have enacted a law. It's not enough to say that. Of course, you had a political. That's a historical fact. We are not countering or disputing that basis. But thereafter, when you make a law, the law has to be, in our respectful submission and understanding, even-handed. And it has to be even-handed. It cannot oppress a certain community or set of communities in the state so as to obliterate their culture. Whereas you ignore it, as your lordship correctly said, that of course the parliament may do things in grades, etc. But the effect, when we go into this and when you see this, what's happening over here? You are having your entire demography which is changing along the border states over there. That's number one. That has an economic impact. It has a political impact. It has a social impact. And this is enormous. This is not something which is happening just. And this statutory provision is encouraging. So keep aside everything which is, I am first challenging 66 itself. Where is the question of suddenly sort of waving a wand and says everyone before 1966 is fine without any scrutiny at all? Then, yes. So, yes, my learned friend is right. It's not some sort of exemption under a taxing statute or something like that. This is when we look at the preamble, and when you see the value of fraternity, the fraternity is among citizens. Fraternity at some larger quality, a larger level, maybe some global fraternity, etc. But here the constitutional mandate in the preamble is about fraternity among citizens. And that fraternity among citizens is sought to be destroyed by a statute which steps in and which destroys my community. How is that to be countenanced?
What is the impact of Section 6A per se on the demographics? Unless you indicate to the court that the impact of 6A on the demographics of the state.
It encourages retention.
Is to destroy the cultural demography of.
Yes, it does. But these are the facts.
We have to have data.
But this is the data.
Data, as we said to you,
yeah,
is data which goes on right through to 2011 and 2020.
But that's what I have.
And Assam undoubtedly has a problem. There's no doubt about the fact that there is infiltration, but we are not testing here. The constitutional validity issue is on the cutoff which has been adopted.
No, the scheme. No, that's too narrow. It's on the full scheme of 6A.
The Assam Accord. What did the Assam Accord do? So we must understand the Assam Accord.
Yeah.
There was an agitation.
Correct.
By the All Assam Gan Sangram Parishad, by the All Assam Students Union.
Yes.
Their basic grievance was that Assam is being invaded by foreigners, by illegal infiltration.
That is
the government of India is doing nothing about it. All right, that was the core of the students movement in Assam. An accord is arrived at. We are not saying that it is sanctimonious, but what does the accord really say? Even the agitators said, all right, what has happened up to now is fine. What happened until people who came in between 66 and 71, delete them from the electoral roll. We don't want them to vote for 10 years. After 10 years, they will be restored broadly. This was a scheme, provided they are identified.
So that was the bargaining that they agreed to.
That's right. So that even the agitators who were agitating at that, and that was not an isolated movement.
But we are also agitators. We've mentioned.
So what was the agitation?
Right.
The agitation essentially was curb the infiltration. The political compromise which was struck was this: those who came before 71, 66 to 71, leave them alone. Now they have assimilated in India. 71 onwards, you have to be absolutely ruthless. Don't allow anybody post 71 to. And Mr. Diwan, you are right. We are not saying your petition is wrong. Your petition highlights a very significant problem that post 71, nothing has been done by successive governments to curb the infiltration. There you are right. But that's not what we're trying to do. That's not an issue of constitutional validity. That is about the enforcement of law.
No, that's assuming the law is valid. That's my second argument. My first and primary argument is this: could you do that? I've indicated in the morning the broad heads under which we are challenging it, etc., which I will come to. But what this is operating, when we see the working of 6A as it stands, keep the implementation aside. Just 6A as it stands, according to us, is there is no justification for this.
One
There may
point
be
you
some,
can make
sorry,
that by making a provision like 6A,
right.
you are encouraging illegal people to come in the hope
No,
that
not
one day we will be also
encouraging.
given amnesty. That you can say that. Up to that, you can really say that, look, by making an argument like 6A, by making a statute like 6A, you're holding out some sort of an expectation for people that this will be extended in the future. But I don't think that has happened. After 86, has any law been enacted by Parliament that 71 is extended to 81? It's not like those slum dwellers, who constantly get an extension of the cutoff date for regularization.
No, you see the effect, I'll explain that effect. The effect is absolutely devastating, because what has essentially happened is that there's a notional statutory provision which is there, but the whole situation remains on the ground. That's why we read those portions and the riots, etc., right until the filing of this petition. We have documented what has happened over there. And the violence which is taking place is also because people are finding.
You're right. The impact is very severe. I mean, that your data subject to hearing.
Yes, and we are going, yes, we are.
Indicates that. We are not, therefore, please don't get it wrong. We are not belittling what has been said in these reports, like the Law Commission, the Brahma Committee report. These are official committees, no doubt about it. But we are only on this that the answer is very different. The answer, in fact, perhaps your petition, which has been lying for the last 8 years, pending reference, if this reference was not made, the court would have passed a series of orders for enforcing the law in this petition. But this reference, in fact, preempted the court from passing those orders.
No, it didn't preempt. The division bench retained session of the matter and continued to pass directives. But anyway, so let me just complete the groundwork now, because that's extremely important. Because factually, as your lordship correctly says, that this is really a pressing issue on the ground over there. Then as to whether I will, of course, naturally, once I complete the groundwork, go to the statutory elements, the constitutional elements. But please go to page 2711 for a moment. 2711. Yes, please just have a look at the right-hand column. Right-hand column loads about 6 or 7 lines up, from the foot of that table. You will find table 3. It's talking now about languages. So please just see, table 3 represents the details of language groups. Table 4 represents the district-wise percentage of language during 51 to 2001. The area considered undivided 9 districts of Assam in 1951. It is observed from table 4 that the percentage increase in Bengali-speaking population is inordinately high than all the other groups of language. During 51 to 2001, the percentage of Bengali-speaking population has increased by 6%, from 21.2% to 27.5%. But during these periods, the proportion of Assamese speaking people in Assam had declined by 9%, from 69.3% to 60.8%. The percentage change of Hindi, Nepali, and other language-speaking people is only 1 to 2%. Then it goes into further details. Now, just please have a look at the next page, which is 2712, right-hand column. Due to the historical links, geographical and physical proximity of migrants of the Northeast India are mainly from Bangladesh. The state of Assam has 262-kilometer border with Bangladesh. Out of the 92 kilometers is riverine. Therefore, migration from Bangladesh to Assam is much easier. Since Bangladesh is a Muslim-dominant country, therefore, to know the impact of cross-border migration on religious change, it is essential for us to compare the growth of Muslim population on both sides of the border. In Bangladesh, the average annual growth in per thousand Muslim population during 74 to 91 and 91 to 2001 are 29.1%, 29.1 and 18.7 respectively. But corresponding Muslim, sorry.
This actually gives
So you see, I'm just placing this thought, sorry. This will go to the doctor only.
Table 4 in that, there's something very interesting in table 4.
Yes, table 4, I have it here.
You know, if you see I'll thank my learned brother Justice Manoj Mishra for pointing it out to me actually. Manoj, with your permission, I'll just share it. 1951, see the Bengali population is 21.2, dips to 18.561.
Your Lordship is Bengali population here.
Bengali population.
Right, 1951, 21.2.
Then dips to 18.5. 71 increases to 19.7. And then see what happens. 91 becomes 21.7% and 2001, 27.5%. So it must be that is the critical part, the critical period where the demographics really change. On the other hand,
This is a percentage.
Look at Assamese, 5169.3 keeps on being constant around the same 70, 69.4 and then 60.8 in 2001.
Small says.
So the problem which you are referring to seems to have occurred between the decade of 1991 to 2001. You really see the
Bengal has increased.
This is not necessarily
thing. Between 91 and 2001, the Assamese percentage of population has reduced from 69.4.
This is linguistic.
Linguistic.
Language.
Language. Assamese linguistic population in Assam has reduced from 69.4 to 60.8%.
Yeah.
Over the same period, the Bengali speaking population increases from 21.7 to 27.5.
Yeah.
So the critical decade really in that sense has been 1991 to 2001.
No, but that is because of the impugned provision. And I'll tell you why. Because
Why do you say that? That's an area where frankly,
No,
not able to get your
so
logic.
I'll just
You may be right. If you can
no,
just
I'm
explain
just
it.
indicating 2 points and I'll develop them. But I'm just planting this. Just consider it because I think all these issues have to be rolled around in one's head and different thoughts will strike you. The first point I want to make is that if you are giving legitimacy or citizenship, this is a huge thing, citizenship to somebody who has entered at a particular point of time, then, and you are recognizing and protecting, I think it's reasonable to expect that those people will also have children. And you will have a multiplier effect, therefore, in subsequent decades, etc., so therefore, you are at inception, you are allowing somebody in, but the multiplier impact may take place subsequently. That's why your lordships have seen those other tables, which I've also referred to, where the population, not just language, because this is the linguistic thing, but the populations themselves increase. And it's likely that the future decadal language will be the language which is primarily spoken by the parents. It's possible. I think it's reasonable to infer that. That's the normal course which is likely to happen. So that's one aspect I want you to just consider. I'll then complete this table. The second point I want your lordships to just consider is that please look at it. We are concerned as writ petitioners with our rights, etc., for sure. However, look at the manner in which the statute operates. If you are someone illegal who has entered into another border state from the very same jurisdiction, you enjoy no protection at all. You enjoy no protection. So, because there's a historical fact which I'm not disputing regarding an agitation, there is a whole set of rights and entitlements all the way up to citizenship. I can understand, as was being suggested, that you have some intermediate right for people who have come during a particular period. But it must and ought to fall short of citizenship is what my primary concern is. Because otherwise, my land will go, and is going and has gone to a great extent, economic impacts, cultural impacts, and then eventually the political impacts are going to be enormous. So therefore, I just leave you with these two thoughts. Number one, in terms of as far as the future generations, progeny, etc. are concerned, and how that might impact as far as the numbers is concerned, the next generation and the generation after that. And yes, which is really part of the effect test. And the second element which I want to point out is that you ought not, you can, of course, you have some flexibility of policy, etc. But the situation here which is obtaining is, from the very same village, two people set out. One is an illegal migrant who crosses the Assam border. The other person is an illegal migrant who crosses the West Bengal border. The person who comes into Bengal is conferred citizenship. In Assam, is conferred citizenship under the statute. And look at the impact downstream and for future generations. So anyway, I'm just leaving you with that thought. Let me just complete these tables and some of these findings. So the last part of this report, this paper or study is 2713, left-hand side. And then I'm done with this paper. Then I go to the last set of documents I'm relying on. Please see conclusion, Roman 4 at page 2713, left-hand column. The empirical analysis based on district-level census data shows that the proportion of Muslim and Bengali-speaking population are rapidly rising during 51 to 2001 than other religion and language. This unusual high growth is not only from the natural increase alone. The natural growth rate of Muslims should not have been much difference between Bangladesh and Assam. But the difference in actual rate clearly confirms the migration of Muslims to Assam. The unusual high growth of Muslims and Bengali population in Assam may be due to cross-border illegal Muslim migrants from Bangladesh to Assam. It's a matter of grave concern because if the change of proportion of religious population continues with this trend, then it is possible that the Assamese Hindu becomes a minority in their own state. In present study, from the statistically projected trend, it is found that the Hindu and other religion will become a minority in comparison to the combined proportion of the Muslim and Christian population after 2040, the former governor of Assam, S.K. Sinha, expressed this in his report in 1998 that illegal migrants threaten to reduce Assamese people to a minority to their own state, as happened in Tripura and Sikkim. So this was now I'm done with this particular table. Now the third and the final, or the next and the final document which I want to refer to is a report which your lordships will find is at serial number 51 of the same report, page 2912. The investigators are the investigators for the report are also indicated. Cross-border migration in Assam during,
Between Assam. Page
I'm
2912.
suggesting 2912 of the very same volume 4. And your lordships have a paper titled or a study titled Cross-Border Migration in Assam during 51 to 2011, Process, Magnitude and Socio-Economic Consequences. Perhaps at page 2912. It's at, I think, in the index, it's serial number 51.
Yes, this is Dr. Nandita Saikia and Dr.
Yes,
William.
yes, Nandita Saikia and Dr. William Joe. Now, I'll just indicate what I'm going to do here. I'm going to only point out certain sets of conclusions which are for in various chapters of this particular study. So please turn first to page 2946. Chapter 2.
Page 29.
46, same report. The study itself, I might just indicate, begins at page 2912 and it goes on till 3091. I'm going to just read certain conclusions which they have got. Now, please see page 2946. This is at the head of chapter 2, Demographic and Socio-Economic Composition of Assam. Key findings for chapter 2. The fertility rate is lower in Assam than in India, and the mortality rate is higher, but the population growth over 2011 to 1991 is substantially higher in Assam than in India. In comparison to India, the percentage of urban population is nearly half in Assam, and the infant and adult mortality rates higher. Percentage share of Muslim population has been increasing from 25.37% in 1951 to 34.23% in 2011. Among 8 undivided districts of Assam in 1951, 5 districts experienced a sharp increase in Muslim population. Assam and India have a similar literacy rate. In Assam, demographic indicators vary widely by religion, caste, and district. Population density varies widely and is higher in Muslim-dominated districts. Muslims have a higher fertility and mortality rate than Hindus in Assam. Next, please go to page 2961.
Thinking.
Because I was requesting the court to turn to page 2961. Page 2961, chapter 3, correct?
Yes.
Trends in immigration in Assam, 1951 to 2001, evidence from direct and indirect demographic estimation. Now, their key findings are, both direct and indirect estimates reveal that Assam is the destination for the migrants, mainly from East Pakistan, Bangladesh, Nepal, and Myanmar, before and after India's independence. On average, 90% of the immigrants in Assam are of Bangladeshi or East Pakistani origin. Census report on immigrants has been substantially underreported in post-Assam movement period. Indirect estimates show, assuming 1951 as the reference period, the number of ever immigrants, these are people who came in after 1951, ever immigrants and their descendants in Assam as high as 4235124 in 2001. In 2001, every sixth individual in Assam is either an immigrant who entered in Assam after 1951 or their descendants. They constitute approximately 15.88% of the total population of Assam in 2001. So this is the effect and impact which this is happening. And of course, it's disproportionate in different districts. Your lordships have already noted that, particularly concentrated in the border districts. And if we are scheduled tribes or even non-scheduled tribe individuals residing in these border districts, the impact and is immense. Now, may I request you to go to page 2985. Chapter 4. Demographic and socio-economic differentials among natives, old settlers, mixed and immigrant population, analysis of the primary survey. Key findings of Chapter 4. Immigrant and old settler villages have a younger age structure than native villages. Immigrant villages have a higher share of young population. Thus, young age dependency is more amongst immigrants. Native villages have a higher share of older population. Old age dependency is more amongst natives. Immigrants have more children ever born than natives. Only 44% of the immigrant women have fewer than 2 children, but over 75% of the native women have fewer than 2 children. Also, the perceived ideal number of children is higher amongst immigrants than natives, 65.9 versus 42.7. Similarly, average perceived age at marriage is lower amongst immigrants, immigrant origin women, and native women. Over 96% of the native families report Assamese or other native language as their mother tongue, against 60% of the immigrant families. Over 89% of the natives are Hindus, whereas 97% of the immigrants are Muslims. Among all settlers, 20% are Hindus and 80% are Muslims. Only 31% of the natives, but 99% of the immigrants are of general castes. Over 9% of old settlers are SC. Over 7% of natives have government jobs against 2% of immigrants. Out-migration is higher amongst immigrants, 3.3%, than among natives, where it is 1.6%. The next set of conclusions for Chapter 5, you will find at page 3010. And this chapter is titled Magnitude and Dimension of Intergroup Inequalities Between Migrants and Natives. And the key findings. In general, all households in surveyed area have inadequate access to basic amenities. For example, only 20.7% of the households have access to a flush toilet. Only 33.7% have pakka or houses made of solid material, and only 20.3% of the households have clean fuel for cooking. However, relative position of immigrant households was bad. Say only 7.3% of the immigrants' household have a flush toilet, 13.4% have brick houses, and 9.3% use clean fuel for cooking. Despite immigrants less educated than the rest, registration of births are highest amongst them. The reason of higher birth registration may be the motivation to establish their legality in the current place of residence. So when your lordship examines the effect test, which is a standard manner in which your lordship examines whether a statutory provision is constitutional, which your lordships may also keep in mind. In terms of receiving the government subsidies or government benefits, there exists only marginal differences between native and immigrant households. Say the percentage of households receiving the benefit from government is 34.7% for natives and 31.9% for immigrants. Government beneficiaries were the highest in mixed type of villages, 44.7%, amongst them. Permanent method of family planning is more popular amongst native women, whereas temporary method appears to be popular amongst immigrant women. When it comes to visiting health workers, a larger percentage of native women visited doctors than immigrant women, 85.3% versus 66%. Proximity of service. Suggestions received